Supplementary list item number 1 for judgment.
In the result, the jail criminal appeal is allowed, the impugned judgment and order of conviction of the appellant and the sentence passed thereunder is hereby set aside.
Big pardon, my lord. Item 196, my lord. The main accused has been released on bail, my lord. I am the person to help them to arrange a room, the victim and the
We'll see that
more
when
than
the
5 months in custody.
matter is
196.
Item 206. The main application for interim bail on the grounds the accused person is suffering in cancer, Your Lordship. Last Friday, I have also mentioned, Your Lordship.
Instruction has been sought.
Yes, yes. Last
We'll see. So filed a mark for
206, Your Lordship.
interim
I
application.
may be instruction to ask.
All right. Yes.
I may be part.
My lord, item number 284, 285, 286, my lord. They are juveniles, my lord. Close to second year students, my lord. And will be taken out to them.
They are in custody.
Custody since 15/9/2023,
So
my
have
lord.
you obtained the? Is it coming for the first time?
Yes, sir, first time.
Then you obtain those. See that whether the case diary and social investigation report.
Yes, yes, that has been 284, 285, 286.
Filed a magi dekhant. All right.
I may be partner also one CRL number 1834/2023. So it's in this case the LCR has already been called for and the LCR has been sent. But since it is sent through soft copy in a different to PDF format, it is not being listed, Your Lordship.
What is the matter?
It's a conviction under section 370 is the abator, is a lady and is
It's a bail matter.
bail matter.
Give see that why it is not.
Pardon, my lord. Item number 254 of weekly list, my lord. Instruction has been sought for interim bail.
Interim bail.
Interim bail.
Achha.
254, my lord.
Take down the number and see whether that instruction has come or not. 254.
254.
Yes.
Pardon, Your Lordship. Your Lordship, of fresh criminal appeal arising out of conviction, Your Lordship.
Keep it.
Pardon to make a mention.
Another fresh bail application, Your Lordship.
Give it.
Pardon to make a mention, my lord. On behalf of Mr. M.K. Mahabhadra, item number 255, my lord. Here the petitioner is in custody since 1/8/2018. Lord, investigation has been progressed a lot and more than 50% of witnesses has already been examined, my lord.
All right, we'll see that when the matter reaches.
My petitioner in custody since 4 years. Tied up matters.
Give it. Yes.
My lord, item number 262, my lord. Second time it is coming.
Hmm.
Custody since January 23. May I pray, Lordship, kindly taken up?
We'll see that. Yes. Next.
My lord, item number 172, we filed for an interim. It is today, posted today. If it is not reaching, then kindly.
Interim bail.
Interim.
On what ground?
On medical conditions of the mother of the petitioner.
Instruction has been sought for, or it is coming for
No,
the
it
first
is
time?
coming for the first time.
First time. Take instruction. What is that number?
172.
172 रे ଗୋଟେ I ଅଛି element of this one, so state council is to obtain instruction. Yes.
Pardon to mention, my lord. Wiki list 232, lordship.
Yes.
Has verification of documents, lordship. Only.
Well, let's see that it if the document is yes.
232.
Call the matter.
Lordship, another item 127 is disposed by Honorable Justice B.P. Rautrai.
We'll see that when the matter reaches. Yes, call the matter.
Item number 1.
Rani.
That report has come.
Kindly pass over, your lordships. Item 2.
Flag? Where is that flag key?
কালি রিসিভ করলে তবে
Supplementary আসলে পড়লো না।
That is a old status. Well, it pass over.
I beg pardon, my lord. Item 1.
One, the notice has been served yesterday only on the
Next Friday, your lordship, on
non
15th.
non-appeals cutting.
On 15th, your lordship. Supplementary list.
All right, 15th of the month.
Oblige.
Item number 3.
Mayor village or Simalors. Present petitioner, my lord. Is the behind bar, my lords.
Wait.
Arrested.
Asutosh Mishra.
So where is that SCP Asutosh Rana
Not Rana Mishra, that is mistake. Asutosh Mishra.
Misra?
Yes.
Where it has been mentioned as Rana in the charge sheet or what? Could mention is
No. Rana to
please देखिए charge sheet में charge sheet copy was produced on that day. Show me that charge sheet which you produced on that day. That is charge sheet dated 13/1/2022. Is it available?
I have passed on that.
Pass on. Give that charge sheet. 13/1/2022 charge sheet.
Certified copy টা ছিল। Written? Yeah. Right. এটা? Revision? Sorry, এটা ঠিক তো?
No, this is 19/1. I went through the charge sheet dated 13/1/2022 on that day.
So that is not available. After that, you for which lordship directed the Lorna State
No,
Council?
you produced on that day the charge sheet dated 13/1/2022. I searched for the earlier charge sheet, it's all right, but yes, this is the charge sheet dated. Not going through the. This is available. Asutosh Mishra, not Rana.
Yes.
So please show that charge sheet to him. Have you gone through the order passed on 1/12/2023?
Sir, sir.
Huh?
Sir.
So which is the provision of CRPC in which further investigation is kept open?
Sir, it is 173 clause 8, sir.
Why have you mentioned in charge sheet 178 subsection 3? It's a sensational case and you are a rank of ACP and you will mention this type of provision inadvertently. Not only one place or two places you have mentioned. No, 3 places. In the last column, previous column. I called you, I thought that you are to be sent to that Biju Patnaik Institute where the training is being imparted. And what is the allegation against this man, Lala Amrit Sagar Roy? As per the charge sheet you submitted previously, because this charge sheet confines to only Satyam Pradhan. Yes, Mr.
Yes, ma'am.
I mentioned in that order, Mr. Tripathi,
Yes, ma'am.
since 3 petitioners are before me in
Yes.
connection with this particular case, I want that where is that portion of the charge sheet where the accusation against these 3
Yes, yes.
petitioners have been summed up. Lala Amrit Sagar Roy, Lilima Lenka and Devasis Hajra.
instruction ତ ଆଣିଛନ୍ତି ସେଟା ଦେଇଦେବୁ କୋଉଠି ଚାର୍ଜସିଟ୍ କୋଉଠି ୟାଙ୍କ ନାଁରେ ଅଛି
There is when I rejected the fast bail application, I thought that for each of the accused, one paragraph is devoted, that this is after summing up. So that is how I have mentioned also for those petitioners. But these petitioners were not applicants in that bail application.
Yes,
so
ma'am.
worry
That
that
is
has been
the-
summed up. You are not having that. How you are conducting trial then? That is surprising. You do not know you are conducting trial for a person.
no.
You have not got the charge sheet of that person.
Preliminary charge sheet is me, but the preliminary charge sheet, final charge sheet, just a replica of a preliminary charge sheet. Only name of Satyam Pradhan has been added.
No, Mr. You are giving it in the. Please show me that. portion
yes
of
yes
the charge.
that is the underline that
I'm passing it over. Do all these matters. I'm passing it over. This
Yes,
is
ma'am.
not just it's a lack of preparation. Yes, all these three matters I'm passing over. Just yes, next. What about item number 4? I think it's a different matter.
Item number 4.
In item 4, I am filing the copy of the surrender certificate.
Letter received by the apex court in SLP. What is this letter?
Against that order of your lordship, rejecting the petition for extension of interim bail, it appears that the petitioner had gone to the apex
What is
court.
that order?
This is the copy.
Flag X. Okay, just taking into consideration the fact that the main application is pending consideration in BLFPL number so and so, and without expressing any opinion on the merits, we request the High Court of Orissa to take up the said matter and dispose of the same within 2 weeks from the date of receipt of the copy of the order. Okay. So you are granted interim bail.
My lord,
On what date?
your lordship granted interim bail by order dated
16/2020.
6/10/2020
That is
for undergoing knee surgery of his wife.
okay.
Then your lordship directed the matter to be listed
Right.
for filing of surrender certificate, but he moved for extension, my lords. And that your lordship rejected on 10/11.
Right. Then when
Thereafter, my lords, the petitioner had moved the apex court. The order of the apex court is
30/11/20.
Yes.
Right.
and pursuant thereto I have surrendered.
Okay.
My surrender is on dated 4/12/20.
Where is that surrender certificate?
I have it.
Right. Lekon to peruse the order dated 30/11/2023 passed by the Honorable Supreme Court in specially petition bracket criminal diary number 48815 of 2023. Wherein a request has been made to this court to dispose of the bail application within a period of 2 weeks from the date of receipt of the copy of the order. Mr. Devasis Pandal and counsel for the petitioner. produce the surrender certificate. It is taken on record. Yes.
Please, ma'am.
Yes.
Lords, I am in custody here since 14 to 2020 in connection with an offense.
Just a minute. 2023. Yes, the date of custody is
Date of custody is 14/2/23.
okay. Charge sheet submitted under
Yes,
section.
charge sheet has been submitted under 20B2C and 29 of the NDPS Act on 17/10/2020, my lords.
17/10/2020.
My lords. And this charge sheet was against the 4 accused who were apprehended and were in custody. 5 accused. Charge sheet is against Muhammad Asadul Usman Khan alias Kanu, Sarath Sahani, Kanu Chandra Bardhan,
No,
and
if in
Lokman.
the first information report, your name is not there.
No, in the first information report, my name is there on the basis of confession of the accused who were apprehended.
5 persons were apprehended.
Yes. Would your lordship look at annexure 1 of the bail application, running page 11, my lords. That is the plain paper FIR.
Yes. Please come to page 8. That would be better.
Yes.
I just want that. Who are those persons who were apprehended?
Right, my lords. The persons who were apprehended are Muhammad Asadullah.
That is number 1.
Yes.
Yes.
Kanu Charan Bardhan.
Yes.
Sarath Sahani. Number 3. Then Usman Khan and Lokman Khan. I am at serial 6.
They disclosed your name.
Yes, my lords. That is,
in what connection?
my lords, may look at page 11 now. In the first paragraph, my lords, at the end, your lordship will see 4 lines from the end of that paragraph. Sentence begins, they also confessed that Indramani Settha 40, son of so-and-so of Bindhania, and Pranava Sahu alias Pintu, son of so-and-so, both of PS Tigiria, are the main persons dealing with ganja trading and absconded today seeing police.
Okay.
So on the basis of this statement, my lords, recorded in the FIR, I am named as an accused in the FIR. The charge sheet which was filed on 17/10/2020 styled as a preliminary charge sheet is against the first 5 persons who are named in the FIR. Till date, no supplementary charge sheet has been filed.
No, they, you were taken into custody on 14/2/2023.
My lords.
When during course of that further investigation.
Yes, my lords.
So, Mr. Tripathi, is it correct that he was taken into custody on 14/2?
14/2.
So, when you have submitted the first charge sheet on 17/10/2020, you are keeping the further investigation open. Then you are taking him into custody on 14/2/2023. Then the maximum period required for you to submit the charge sheet against that person is 180 days.
180.
So if you do not file the extension application as per the provision enumerated, then he is entitled to be released on bail.
No, I have no instruction regarding that.
That Mr. Panda says, that is why
Yes. We have to filed any extension or not?
Why have you not filed, Mr. Panda? That's a decision of this court. That
your lordship's
yes,
judgment.
180 days. That's a
Yes.
clear-cut provision is there.
My lords, a revision was filed against an order of the trial court, my lords. That is criminal revision number. I am giving that number. That
Because,
revision has been rejected.
Revision against what?
Your Lordship may see this order.
Okay.
Order
I
dated
thought that
60
whether
days.
any attempt has been made there or not.
Aye, 16/8/23 order.
So that attempt has been made. It's
Aye.
all right.
ये reject हुआ.
When you challenge the order, what happened before?
No, that has been rejected by a coordinate bench of this
All right,
court.
leave it there. Yes.
In criminal revision 490 of 20.
All right. So let us leave that. So now, Mr. Tripathi.
Yes, sir.
So, whether it is correct that the only material is the confessional statement of co-accused,
That is true.
and when he was arrested on 14 to 2023, did you find any incriminating articles from his possession or from his house search, anything like that?
I was produced on remand, my lords.
Okay. Oh, there is an. So how many cases are there?
But similarly, in cases
That
at
is-
Ranchi are there on the basis of confessional statement.
3 criminal antecedent, 2 numbers are NDPS case.
So you have got those numbers.
In all those cases, he is on bail. We have
No,
filed a
just,
set.
I just want a comprehensive affidavit. That's all. Please give those number and that affidavit. Have you got those number? 3 numbers.
Yes, Lord.
All right. Take down the settle youth election. Mr. Pandal and counsel submits that the petitioner was arraigned as an accused in connection with this case on the basis of the confessional statement of 5 co-accused persons who were apprehended at the spot for transporting commercial quantity of ganja in a vehicle, na?
Aye.
In a vehicle.
There are two vehicles.
Acha, in 2 vehicles. And the first charge sheet was submitted on 17/10/2020, Mr. Pandal,
Yes.
under section 20B2C only
And 29.
and 29 of the NDPS Act against those 5 co-accused persons who were apprehended at the spot.
Serial numbers 1 to 5 in the FI.
Serial number 1 to 5 in the FI. And the petitioner was shown as an absconder.
No. The petitioner was shown. Your Lordship may look at Annexure 2.
That is the observation in that.
Your Lordship may look at Annexure 2. What he writes there is
Annexure 2 is the copy of the
charge
serial
sheet.
list. No, acha, 3 is the charge sheet. Yes.
Yes, 3 is the charge sheet.
Yes.
He has stated, page 32, running page 32, your Lordship.
Mhm.
Received orders, last paragraph.
Mhm.
Received orders from SP Kondhamal by letter dated such and such to submit charge sheet against accused, namely so and so, under section 20B2C 29 NDPS Act, showing absconded accused Indramani Seth and Pranav Seth alias Pintu, wide CS number 41, keeping investigation open as per provisions of 173.
Mhm.
The grammatical meaning, milords, it appears that investigation has been kept open against them.
Mhm.
There is no list, no column in this charge sheet showing me as an abscond.
There is a Mr. Tripathi. If you file charge sheet against a person who is arrested, or if you file charge sheet against a person who is an absconding, that is to be in prescribed form.
Yes, that is.
And in that prescribed form, you have to mention absconding. Or
And
if he is arrested, date of arrest, date of. So that page is, they are available in that charge sheet. Mr.
No.
Panda says no. So merely writing that would not do. Other things are to be there. All right, those are matter actually. So leave it there. So the Learning Council further submits that when the petitioner was taken on remand in this case on 14/2/2023, nothing incriminating was found against him. And no incriminating articles have also been seized from his possession. The Learning State Council, after perusing the case diary, while not disputing the submission made by Mr. Panda that the only material available against the petitioner is the confessional statement of co-accused before police, submitted that apart from this case, 2 cases or 3 cases?
3 cases.
There are 3 similar cases.
Yes.
No, 2 are similar, 1 is
Acha,
three are similar.
three similar cases pending against the petitioner in Ranchi.
Yes.
In Ranchi. A copy that those numbers are
Jharkhand, yes.
Acha,
Those
in,
numbers are there.
in the state of Jharkhand. The Mr. Panda Learning Council submit that he's having the
Copies
case,
of the bail orders.
Numbers of those cases, including the bail orders. And he intends to file the same with the affidavit.
Yes.
With an affidavit relating to the status of those 3 cases. Put up this matter on 15th of December 2023.
But I have served a copy of those
bail orders.
bail orders.
Copies of bail orders served on the land. You also filed for the court also? Okay. Yes.
I'll file that with a memo and
Okay.
the affidavit.
All right.
Item 8.
Absolutely.
8, Mr. Roy.
Item 9.
Please, my lord.
Yes.
On the last occasion, your lordship was pleased to call for a status report and copies of depositions of witnesses.
Out of 59 charge sheet witnesses, he has instruction about examination of 29 witnesses by now. And some witnesses have also been declined by the Principal Land Council. Deposition copies of 28 witnesses which are taken. However, he submitted that deposition of PW 29 is not available with him. And today is also the date fixed for examination of witnesses. Status report we called for so and so. Number of witnesses declined. Approximate time required to complete the evidence of the if any witness have been examined today. Land Council shall also send the deposition copy along with the evidence of PW. Okay. Status report at flag. With reference to so and so, I am to submit that ST case number in a posted to so and so. Out of 59 charge sheet witnesses, the prosecution has already examined 29 witnesses. Informant is dead as revealed from this one. So 11 number of charge sheet witnesses have been declined by filing declining memo so and so. No witness was examined on 24/11/2020, keeping in view the progress of so and so. Complete 4 months early. So now the position is that 29 witnesses have been examined, 11 have been declined. So that number comes to 40 and out of 59. So you have gone through the deposition copies.
Yes, the oral declaration are there.
PW 29's evidence has the court sent.
It was is PW 29 evidence. हाँ पठेइजंदी पाई नहीं थी अपन.
No, ମୁଁ ପାଇନି.
Wait,
Let
just-
it come on
just-
next Friday, my lord,
Just
so
a
that I
minute,
will
let me
go
see
through
that.
and
A PW 29 evidence. हाँ पठे दीजिए. So I'm the business owner also received a telephone call to inform me on blood friend Thangia and I called the IH agent. Major. So I'm handing over the copy to you, both of you,
Yes.
PW 29. All right. In pursuance of the order dated 24/11/2023, the London Trial Court, that is Additional Session Judge Salepur in ST case number 32 of 2021, has filed the status report, wherein it is mentioned that out of 59 charge sheet witnesses, the prosecution has already examined 29 numbers of witnesses, and the informant of the case is dead, and 11 numbers of witnesses have been declined by the prosecution. The London Trial Court has also sent the Xerox copy of the deposition of PW 29 as per the order dated 24/11/2023. Let a copy of the deposition of PW 29 be handed over by the registry to the Land Council for the petitioner as well as Land Council for the state during course of the day. Put up this matter. You want it 15th? We'll put up this matter on 15th December 2023.
after that there is no other date.
हाँ
तापर ଆଉ date नहीं 22
हाँ ये जो ये सुनो हमें रजिस्टर को अपेक्षा करनी ताको एटी जेरोक्स करिके दे दियो है ना. Yes.
Item number 10.
Mr. Patnaik.
May I please? 20 bit issue.
Just a minute. Let me see the previous order. Flag B. I'm to submit that the accused sworn for surrender at right time after availing the interim bail period, and out of 21 charge sheet witnesses, 8 witnesses have been examined. Okay. So this is a case of the year 2020.
My lord. Quantity of ganja is 41 kg 850.
When you are granted interim bail?
My lord, 1/12/2022 in BLPL 9068 of 2020.
Just a minute. 2023. A bail application na would earlier bail application?
Olga, BLPL 9068 of 2022.
Have you got that copy of that order? Pass on. এই 9068/2022 পরে ଆଉ ଆସିନଥିଲେ
the present application is pending.
Okay. Yes, Mr. Tripathi, Mr. Das, interim bail ले ଯାଇଥିଲେ ଏବଂ surrender ଠିକ ସମୟରେ କରିଛନ୍ତି ବୋଲି report ଆସିଲା. Part the London Council for the petitioner, London Council for the state. এই অর্ডারটা ଦେଖିକି ଲେଖିବେ ফার্স্ট বেল আপ্লিকেশন 3 মাস ଯାଇଥିଲା, এটা হচ্ছে সেকেন্ড বেল আপ্লিকেশন ହେଲା, ମୁଁ ଲେଖି ଦଉଛି এটা সেকেন্ড. आधेरे भी 3 मास गला है ना सेटा लिख देबे then as for the status report submitted by the London trial court, it reveals that after availing the interim bail period, the petitioner surrendered at right time. And out of 21 charge sheet witnesses, 8 witnesses have been examined so far. Again, 3 months bail granted, disposed of.
Oblige, Lords.
Yes.
Item 11. Item number 12.
Please, your lordship. The last occasion, your lordship was pleased to call for the criminal antecedent of the petitioner along with the post-mortem report. I have collected those records. These are all case and counter cases of 2009. Offense under petty offenses 323, 324, 354.
Wait. There was a direction to you to supply the deposition copies of PW 5 to 10.
You also heard this matter last week. Mr. Tripathi was there, and last week it was there.
1, 2, acha.
Committing to Hens Miller, there was a meeting in the village.
Has received learned counsel for the PW1 to the eyewitnesses who have supported the prosecution case. PW4 is another eyewitness who has not supported the for which he was declared hostile, and all the eyewitnesses have stated that the petitioner assaulted on the backside of the head of the deceased with a cricket bat, and further submitted that he may be given some time to obtain the case diary along with the post-mortem report. So also the instruction about the criminal antecedent, if any.
The witnesses were
sworn submit. Case diary sworn. Yes, what about the criminal antecedent?
No antecedent.
What are those offenses?
Offense. There is no antecedent, Miller.
His name is Bijan Behera.
Yes.
So when you were taken into judicial custody?
Miller, I was taken on 11/8/2022. Out of 5 accused persons, 4 were released on anticipatory bail. And I was directed to surrender and move for bail. There was delay because of extension of time, and there was delay in surrendering.
But you surrendered on
11/8/2022 pursuant to direction of.
And what are the offenses under which charge sheet submitted?
147, 148, 149.
Just go slowly.
Yes.
Yes.
147, 148, 149. 302, 354, 506. 294 of Indian Penal Code.
294?
Of IPC.
Okay. So what is the name of the deceased?
Deceased Miller. PW, husband of PW 1.
Nata kon koyo deceased husband of PW1.
Again, no. Ananda Chandra Naik.
Date of occurrence?
Date of occurrence is on 2011-2020. FIR was on 21st November 20.
So you are the main accused who assaulted by means of that cricket bat.
Cricket bat, one blow. That is the allegation. But all the eyewitnesses consistently, though in chief, stated that I have assaulted. But that bat was
you
not.
Are a cricket player or what?
Why in fact, he was not holding the bat. He was not. That is the.
What is the case of the prosecution?
Prosecution case, Miller, because the PW8 committed death of 2 hen of PW4. By administering poison. There was a village meeting convened in the locality.
Okay.
And the father of this petitioner was the president or who was presiding the meeting. There the dispute started because of some hot words, exchange of words. And after that, these 4 persons came along with the petitioner. They assaulted and others caught hold of him, and this petitioner assaulted. This is the allegation. The PW1, the wife of the deceased, she claims to be the eyewitness to the occurrence on the basis of which prosecution started. But in the cross-examination, she has miserably failed, or she has stated that she was not there.
So is it a case of single blow or
Single blow? Single blow.
As per the PM report, single blow.
This is the PM report I have brought. Last time it was not with. Okay.
Craniocerebral injury due to impact of the hard blunt weapon. All right. ଆଉ କିଛି ଅଛି କେସ୍ ବାସ୍ ଅଛି?
No, no.
Are the learned counsel for the petitioner ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି କି?
Aguru reject ହେଇଥିଲା with the liberty. I was given a
Which
liberty
is
to
that
move
application?
after examination of the
Which is that application?
I have annexed me Lord at page 7. Sorry, page 11.
Page 11.
No, sorry, page. This is the order, my lord.
କେତେଟା ପେଜ କହିବେ?
Page 10.
ସ୍ଥିର କରି କହି ପାରୁନାହାନ୍ତି?
Page 10, your lord, second paragraph. The petitioner is at liberty to renew his bail for bail after examination of eyewitness. All have been accepted.
Vijayan Prasad Behra. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 11/8/2022, and he has been charge sheeted under section 147, 148, 149, 302, 506, 294, 149 SSU of the Indian Penal Code. The occurrence in question took place on 20/11/2020, and it is the prosecution case that during sudden quarrel, the petitioner assaulted on the head of the deceased Ananda Chandra Naik by means of a cricket bat. Earlier, the petitioner approached this court for bail in BLAPL number 8269 of 2022. And as per the order dated 21/3/2023, this court, while not inclining to release the petitioner on bail, gave liberty to the petitioner to renew the prayer for bail after examination of the eyewitnesses in the trial court. The learned counsel for the petitioner submitted that in the meantime, eyewitnesses have been examined and PWs 1, 2 किए के support करजंदी?
Except PW4, PW1. In the chief they have stated, but
अरे कौन तो आगे किए करजंदी?
PW1, 2, 3.
1, 2, 3, 8, and 10 are the eyewitnesses to the occurrence who have supported the prosecution case, whereas PW4 has not supported the prosecution case and declared hostile. The learned counsel further submits that it's a case of single blow, and since at this stage there is no chance of tampering with the evidence or there is no chance of absconding, the bail application may be favorably considered. Learned counsel for the state has placed the evidence of the eyewitnesses examined in the trial court, and so also the postmortem report, which indicates that there is one external injury on the left parietal region of the deceased, and cause of death has been opined to be craniocerebral injury on account of impact by hard and blunt object. The injury has been opined to be sufficient to cause death. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the progress of the trial so far, and absence of any criminal antecedent against the petitioner, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. He shall appear before the learned trial court on each date when the case would be posted for trial and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed. এটা দিয়ে দিও তো।
Item 13.
May I please your lordship? Offense under section 20B subclause 2C of the NDPS Act.
So accused and implicated in this case, basing on the statement of the co-accused.
Is it coming for the first time?
No, my lord. Had order dated 30/11/2023.
And
Lordship directed to the state
just
to verify.
please. ଆଉ ଅନ୍ୟ କିଛି order ନାହିଁ ଅଛି କି order କିଛି ହଁ କୋଉ order କେବେକାର ସେଟା କୁଆଡେ ହେଲା ଯାହା ଇଚ୍ଛା ହବ ତ କରିବ ଅନ୍ୟ ଗୁଡା ଛାଡିଦବ ଦିଅଣ You have received the case diary, Mr.
No, case diary is not available.
And he has submitted that the co-accused persons have been acquitted.
Yes.
And he has perhaps annexed the acquittal judgment.
That is, I have.
So, along with the acquittal judgment, he has also given you the deposition copies.
Yes.
It is his submission that only material is the confessional statement of co-accused.
Yes,
And
that is true.
you are required to verify the same.
Yes.
Is it correct?
Yes.
What about the criminal antecedent?
That is not.
No accident, my lord.
You are a local man.
My lord.
Since when you are in custody?
10/9/2023.
10/9/23. You are an absconder.
For 10 years.
For 10 years.
My lord, order of NW was stayed by this honorable court, my lord.
When it was stayed?
Since 2019/5/2017, my lord.
And that was disposed of when? In 27/1/2023.
My lord.
So thereafter you took 8 months more time to surrender. You challenged the NBW. That was stayed according to you. So either you would have gone to the Honorable Supreme Court against that order, or you would have surrendered. So your conduct, you are awaiting the result of that when that judgment was pronounced.
My lord, 27/1/2023. Honorable court directed to raise the question. I had filed the CRMC to quash the entire proceeding, my lord. This honorable court directed to raise the question at the stage of trial, my lord. My lord, in this case, lordship may kindly see chronic page number 34, my lord.
No, let him get the instruction about the criminal antecedent. So the learned counsel for the state, learned counsel for the petitioner, submitted that the petitioner, you surrender or you were arrested?
My lord, arrested.
Was taken into judicial custody on 10/9/2023. And further submits that the only material available on record against the petitioner is the confessional statement of co-accused before police. And co-accused persons have already been acquitted, and he has annexed the judgment of acquittal, so also the deposition copies of the witnesses. Learned counsel for the state submitted that it's a case of the year 2013, and the petitioner was an absconder for 10 years. Sapara. Learned counsel for the petitioner, on the other hand, submitted that the petitioner approached this court challenging the continuance of proceeding against him in CRLMC number 753 of 2017. And এটা কোন interim order pass ହେଇଥିଲା ତା ଦେହରେ କିଛି?
My lord.
কোনটা interim order pass ହେଇଥିଲା?
NW was stayed, my lord.
And the non-bailable warrant of arrest was stayed, and finally the CRLMC was disposed of on 27/1/2023, giving liberty to the petitioner to raise the funds at the time of trial. Land counsel for the state, while not disputing that the only material available on record against the petitioner is the confessional statement of co-accused before police, seeks some time to verify whether there are any criminal antecedent against the petitioner or not. Put up this matter on 15th December 2023. Free copy of the order be handed over to the learned counsel for the state. Yes. এটা করে কোন কার এটা দিয়ে দিয়ে গেল এটা কোথায় ছিল আচ্ছা yes দেখি দিন
Passo item number 2.
My lord. My lord, the petitioner implicated in the case 307, 302 along with 323,
just a minute.
324. In previous occasion,
wait
my lord.
Came on 1/12/2023, from which it appears that out of 16 charge sheet witnesses, 8 witnesses have been examined. The evidence of the rest charge sheet witnesses, okay. Learning trial court has also sent the deposition copies of so and so. अच्छा उधर status report मंगाई थी okay actually like status report at flag K. Out of 16 charge sheet witnesses, 10 witnesses have been examined. So further, I have enclosed the deposition copies of PW 9 and 10. Where is the copy deposition copy? Hmm, 9 and 10. What? 9 stated do not know. 10 is the okay. SI of police. Achha. He submitted charge sheet. Okay. So now tell me, is it your first application or
No,
not
no,
yet?
my lord. This successive application, first bill application number, BLAPL number 1124 of 2021, my lord. And that was disposed of on 24 August 23.
23.
20, my lord, now 20.
Have you got the copy of that order with you?
No, my lord, that application along with this application. There is a noting, my lord.
1124 of 2021.
My lord.
The Dakko Jena, right? So the order reads like this, okay. They are seated under section 307, 302, okay. Love marriage between the petitioner and one Kabita Palai prior to the date. They were blessed with a girl. Occurring when a quarrel ensued between the petitioner and his wife Kabita Palai, deceased, who happened to be the mother-in-law of the petitioner, intervened. The petitioner stated to have given a blow on the head of his mother-in-law with a wooden flank and also assaulted to his wife Kabita Palai. Okay. One blow given due to grave and sudden provocation, all right. Kabita, from which it appears the petitioner dealt repeated blows on the head of the son. So he also placed the postmortem which indicate that the son sustained 3 external injuries. First one was a lacerated wound on the middle of the skull. Second one, right temporal area. Third one, contusion on the left temporal. The cause of death was hemorrhage and neurogenic shock. Okay. The manner in which the petitioner assaulted his wife and so on so. And postmortem report findings so and so. Absconder for 8 years, not inclined to release him. Expedite commitment so and so. So there is eyewitness to the occurrence.
Yes, ma'am.
So as it appears that Kabita Palai must be the
daughter of that deceased.
Right. She perhaps is the eyewitness.
She is the
She
informer.
has
She is also
another
informer.
one is PW7.
Kavita Palai is PW.
PW9.
PW9 नाम वगैरह deposition.
No. The Kavita Palai examine ही नहीं.
My lord.
He is the star witness on behalf of the. She was also injured witness.
9 की 10 देखो.
She is the injured, so also the
No,
informant of this case, my lord.
9-10 CNM.
निकालना
তাহলে
ताले
Are you sure that 1, 2, 8 ভিতরে Kavita
Yeah.
examine ही नहीं? Then who is the other witness? PW
PW7
7.
non-hostile period. That is eyewitness.
Okay. So let that Kavita Palai, you produce the Kavita Palai because the date now is fixed to 18/12 and 19/12. So you have got time, so you produce. Here is the status report submitted by the London Trial Court, from which it appears that out of 16 charge sheet witnesses, 10 witnesses have been examined, and one witness, which CDSW number 6, namely Priyambada Palai, is dead. And the case is now posted to 18/12/2023 and 19/12/2023 for recording of the evidence of rest charge sheet witnesses. The London Trial Court has also sent the deposition copies of PWs 9 and 10 as per the order of this court. Let the copies of the deposition be supplied to the London Council for the petitioners, so also the London Council for the state by registry by Monday. London Council for the state submitted that Kavita Palai is an injured eyewitness who is yet to be examined. In view of such submission, let the inspector in charge of Balugam Police Station appear before the London Trial Court, that is First Additional Session Judge Khurda, in ST case number 69 of 2021 on or before 13th of December 2023, receive summons in respect of witness Kavita Palai and ensure her attendance on the date fixed. Matter to be listed in the second week of 8th of December, January 1st, শুক্রবারটা কেবে ଅଛି ଜାନୁଆରୀ କ୍ୟାଲେଣ୍ଡର ପଡା ଲାଗି ରଖିନ କି 5 କଣ ମ 5
8 January
5 ଛାଡି ଦିଅ ତାପରେ 5 ପରେ ଅଛି 12 on 12th of January 2024. A free copy of the order be handed over to the London Council for the state. Yes. Okay.
Item number 8.
Mr. Rai, my lord, I may be permitted to place the.
Yes, yes.
Your lordship's last rejection, my
Then
Thereafter, his date was fixed for surrender on 19/8/2023.
19/8/2023, date fixed for surrender.
No.
No?
Thereafter, my lord, his interim bail was extended for another 1 month
By
by this court. By this
on that 19/8/23.
Yes, sir.
No, when it was extended.
19/8/23
Just 19/8/23 रे बाहर करो. Proceed to 19/8/23 ରେ ତ କିଛି ନାହିଁ ସେମିତି. 22/8/2023 ଅଛି, ତା ପୂର୍ବ ହଉଛି 17/7/2023.
1980
okay.
yes 17/7/23
Petitioner is however advised.
5/2023 was.
So 17/7/2023 that was extended. 17/7/2023 रे order is like this. The petitioner is however sworn to surrender to custody on 19/8/2023. ହେଲା 17/7 ରେ କୁହାଗଲା ଆପଣଙ୍କୁ 19/8 ରେ surrender କରିବା ପାଇଁ. ତାପରେ କଣ ହେଲା?
Prior to that, my lord, a present petitioner approached the apex court, my lord, and for which an application of adjournment was filed before the trial court, indicating that matter is subject before the apex court. But the learned trial court rejected that applications and issued process. Subsequently, honorable apex court has also directed that NBW shall not be executed.
Have you filed the order of the honorable apex court?
That is there. That is there, my lord.
Okay.
And
Right. That order was passed on 11th October 2023. And that we are inclined to interim bail to the for a period of 6 weeks subject to condition. Acha. Ei order taku ame extend kari
yes,
chali.
ma'am.
Okay.
So my contention before my lord is that there is a extremely slow progress of trial, my lords. And during of that interim bail, my lord, there is no allegation that present petitioner has misused his liberty in any manner, my lord.
And by the way, what is the allegation against him?
So allegation which is
Pass on that paragraph.
FIR has been registered against unknown persons during course of
one page instruction I have given that.
In the meantime, lordship,
have you submitted a copy to him? Given a copy?
No, I will be.
In the meantime, only one submission. In the meantime, my lord, 3 co-accused persons of the present case have already been admitted to bail, including the then branch manager Satyam Pradhan, my lords. It appears from the charge sheet allegations, and allegations appears to be similar, my lord. Satyam Pradhan was the branch manager, my lord, and manned that branch in single hand man. And the 3 co-accused persons have already been admitted to bail by this honorable court. I have supplied that copy.
Yes, Mr. Tripathi.
Yes, Mr.
What is the difference between this accused and the Satyam Pradhan who has said that he has been granted?
These persons are Lala Amrit Sagar is the main accused.
In what way is the main accused?
He was a gold appraiser.
Gold appraiser, and he has taken that document forged that documents of 2 persons.
No, he is not connected with that bank.
No, he was the employee of the bank.
Okay.
As a gold appraiser.
Gold appraiser.
Satyam Pradhan was
what is the duty of that gold appraiser? Man, jo asibo gahna banda pagi tonka deba puru dekhibe
ballot re rakhibe
to test the veracity.
Vault re jo rakhibe mane seta to branch manager ro daitwa na.
So that is there, man.
Branch manager ro daitwa vault rakhibo au ye
no Miller. No.
Branch managers now.
No document has been seized in that connection.
So gold appraisers are appointed. They are they are in custody of the gold ornament. So with the signature by the 2 appraisers, they only can bill. And the Satyam Pradhan, who is the branch manager, since he was managing the entire affair of the bank and could not concentrate on the entire activities, the Thala Anusagara and Ilivalaka, they have they what happened, my lord? They both the petitioner they took the benefit and they do the entire act of siphoning the gold ornaments, creating false account, everything they have done.
କୋଉଠି ଲେଖିଛନ୍ତି ଆପଣ ନା
Lord,
sheet ଲେଖାନ୍ତୁ କଣ?
Lordship,
wait
with my lord's
Lordship, your Lordship has passed the earlier order.
earlier order ୟା ବିଷୟରେ ଲେଖା
Yes, Lordship has dealt the
No, I just want to see in the charge sheet.
with my lord's permission, I submit only one line. During course of investigation, not a single record has been seized to show that the role, duty, and entrustment of the present prisoner.
I've given a chart also.
wait ଚାର୍ଟ କଣ ଆପଣ ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର ପାଇଁ ଛିଡା ହେଇଛନ୍ତି ତାଙ୍କୁ କୁହାଉଥିଲା କଣ ଅଛି ଚାର୍ଜ ସିଟ ରେ ବାହାର କରିବାକୁ ଦେବେ ବୋଲି ଚାର୍ଜ ସିଟ ରେ ଲେଖିନାହାନ୍ତି କୋଉ ଆକ୍ୟୁଜ ନାଁରେ କଣ ଅଛି କି ଚାର୍ଜ ସିଟ ଆପଣ ଦେଇଛନ୍ତି ୟୁ ଆର୍ ଏନ୍ ଏସିପି ଭୁଲ ପ୍ରୋଭିଜନ ଲେଖିବେ ସମ୍ ଅଫ୍ କରିବେନି କାହା ନାଁରେ କଣ ଅଛି ଚାର୍ଜ ସିଟ ପକେଇଦେବେ Yes, what is there, Mr.
Yes, Lord, that is who does it tonight.
अरे नोट छाड़ନ୍ତୁ म नोट रे किछि लेखाइन मु देखिनी आपण why have there in the charge sheet को charge sheet रे लाला अमृत सागर राय विषय रे लेखा हिची एवं देइछंती आपण एवं कोन ताना एलिगेशन कोन
Yes.
First, that's in the second, that should be.
लाला पाखरु लेखा हिची लाला नीलिमा seized 339 grams of gold from the place of concealment under section 27 of the IE Act.
Yes.
And Then you accompanied the Lala to Mannapuram Finance of Bajragbati branch, and there from that Mannapuram Finance seized 6 kg of gold from various accounts of so and so.
For which separate case has been registered.
That is a separate case. The brother of Lala, while in Mannapuram branch as manager, has also assisted in the process and placed huge quantity of gold with the assistance of the fraud customers. In a case of this nature, the charge sheet should be filed. You see the entire allegation, then you should formulate that you should sum up that what allegation against each individual accused.
Sir, this is the initial charge sheet we have submitted, sir.
जो पर्यंत आपण एई केस रे विभिन्न के जन ना रे मन करंतु 5-6 जन ना रे चार्ज शीट देले इन्वेस्टिगेशन ओपन कले सेई चार्ज शीट रे सेई लोकन ना रे कोन मटेरियल आसिला ताकू सम अप करथांते गोटे गोटे पैराग्राफ नै नॉर्मल जिंस आपण देखै दी गले मु या कली हमको सीज कली से कली बट in this type of case it was required that या ना रे एथिक मटेरियल अछि तापर जो मटेरियल आसीबो पुणी जेतबेले सेकंड चार्ज शीट देबे सब्सिक्वेंट चार्ज शीट ताकू ऐड करिवे इन एडिशन टू दैट व्हाटएवर हैपन एई जिंस ओडा को पाइला पुणी हेडिंग करिवे दैट इज द वे इन व्हिच in a case of this nature charge sheet has been submitted आपन किछि कले पूरा प्लेन लिख दे चली गले ए अक्यूज्ड रो गोटे पैराग्राफ रे टिके आ गोटे अक्यूज्ड रो सेठी टिके सेठू टिके वर्तमान ताकू खोजिला बेलू को कोन आ ना रे अछि इट्स वेरी डिफिकल्ट टू फाइंड आउट you see in the CBI cases how they file the charge sheet in the cheat fund cases you'll find even in these cases which have been OPID Act matters, they sum up the accusation against each individual accused so that one can know, your state council can know immediately that what are the allegation against this particular accused. He need not go on throwing ता नाटा खोजिबो अरे एठी गोटे ता ना अछि ता ना एठी गोटे लाइन अछि तापरे पुणी खोजिबो 5 पेज परे अरे एठी गोटे ता लाइन अछि पुणी ताकू गारो. This is not the way. That would your charge sheet must be such that it would be not only helpful for the public prosecutor but also the accused and also to the court. You have a duty to file the charge sheet in that way. आपण जहा करिसेंती you sum up it and type it out. ए जो जानि नेले 3 जण accused वर्तमान अछंती हला I am taking up this case on next Monday. Sorry, Friday. ए जहा आपण सम अप करछंती ताकू ये कर दो गोटे हेडिंग कर दियो बाहर को जीवेनी जहा आपण लिखिचंती लाला अमृत सागर रॉय तानारे एज पर चार्ज शीट एतिकी जिंस अछि देन लिलिमा लेंका एतिकी मटेरियल अछि देवाशीष एतिकी मटेरियल अछि यू सम इट अप okay and pass on to me, also give a copy to the learned counsel for each of the petitioner. All right, that should be given by Wednesday and case will come up on otherwise it is very difficult to so one line here there the as per the order dated 1/12/2023. এটা কেত নম্বর কেসটা প্রথম ভাই হ্যাঁ 6511 right Other direction thila asiba pai pura. Order. Acha. As per the order dated so and so 1/12/2023, the investigating officer Asutosh Mishra, ACP, IUCAW, has remained present before this court, and he has also produced the charge sheet dated 23/3/2021. ଆପଣ ମନେକର ଆଶୁତୋଷ ନାଁରେ ଏଇ ସରି ଯୋଉ ଇଏ ଲାଲା ନାଁରେ ସେ ପ୍ରଥମ ଚାର୍ଜ ସିଟ୍ ରେ ମନେ କରନ୍ତୁ 23/3 ଚାର୍ଜ ସିଟ୍ ରେ ଏତିକି ମ୍ୟାଟେରିଆଲ ଆସିଛି, ଆପଣ ସମ୍ ଅପ୍ କରିଦେଲେ ଏଠୁ ସେଠୁ ନେଇକିନି ତାପରେ ଲେଖିଦେବେ ଉପରେ ଆଜ ପର ଚାର୍ଜ ସିଟ୍ ଡେଟେଡ 23/3/21 ଗଲା। ପୁଣି ଲାଲା ନାଁରେ ମନେକର ଆପଣ ଯୋଉ ସେକେଣ୍ଡ ଚାର୍ଜ ସିଟ୍ ରେ ଯୋଉଟା ଫାଇଲ କରିଛନ୍ତି ବା ସବସିକ୍ୱେଣ୍ଟ ତା ନାଁରେ ଆଉ ପାଞ୍ଚଟା ଜିନିଷ ପାଇଲେ ସେଟା ତା ତଳକୁ ଲେଖିଦେବେ, ବୁଝିପାରିଲେ? କ୍ଲିୟର? ସେମିତି ଲିଳିମା ନାଁରେ ପ୍ରଥମ ଚାର୍ଜ ସିଟ୍ ରେ ଏତିକି ମ୍ୟାଟେରିଆଲ ଥିଲା, ସମ୍ ଅପ୍ କରିଦେବେ ଟାଇପ କରିଦେଇକିନି, ସେକେଣ୍ଡ ଚାର୍ଜ ସିଟ୍ ରେ ଏଇଆ, ଥାର୍ଡ ଚାର୍ଜ ସିଟ୍ ରେ ଏଇଆ, ତାକୁ ଗୋଟେ ଜାଗାରେ ରଖିବେ, କେବଳ ସେଇ ଆକ୍ୟୁଜ୍ଡ କୁ ଫୋକସ କରିବେ ଆପଣ କଣ ପାଇଲେ, ହେଲା? କ୍ଲିୟର? ଓକେ। Produce the charge sheet dated so and so. However, during course of argument, since in the charge sheet filed in the case, the accusation against the petitioner has not been summed up, comma, the investigating officer seeks time till next week to compile the accusation against each of the petitioners and give an advance copy of the same to the respective counsel. Put up this matter on 15th of December 2023. Free copy of the order be handed over to the Land and Council for the state. Eta niyo.
Interim order भी continue.
Interim
112.
এটা লেখি দেবে তার লাস্ট পেজে ଅଛି গোটিଏ কেবଳ ইন্টরিম অর্ডর ଅଛି, that is in Lala's case, ହେଲା? সেটাও সেই ଯୋଉ ইন্টরিম অর্ডরটাକୁ এক্সটেন্ড କରିଦେବେ till next date, ହେଲା? There is no interim order in the connected cases, Nilima Lenka or Devashish Hajra, right? So this matter should come along with so and so. Okay. Like in the other cases, there was a direction to the IO to remain present.
Yes,
they are
yes.
present.
Yes, sir.
This case also, second case is item number 5, and the IO is Tapos Chandra Pradhan. Is he remain?
Yes,
Is he
yes.
present?
Yeah.
Okay. Accordingly, has he done it like that, or he has to file? Okay, do it like that. So note down his presence, and he has to do like that. Next is the interim order to continue for Lala. Then the third one is item number 6. They are the Inspector of Police, Mr. Amitabh Mahapatra, Mangalawak Police Station.
Yes.
So is he done
No,
this way?
same
Same order. So his personal presence is to be noted, and that is to be done like that. And the number 4 is 7, item number 7, Durga Charan Mahapatra, SI of Police. You are there. So same thing, do it. All right. So all these matters would come on 15th, and all these investigating officers shall remain present. Okay. And in Lala's case, you are just to extend the interim bail order as per the order of the Supreme Court. It was extended from time to time. Now it will be extended till 15th of December 2023. The order is to be communicated to the concerned court. Okay.
Yeah, all cases.
Ajay, the London Council for the you are filing this written note of submission only in this
In the first case.
first
Yes,
case.
yes.
So this is to be kept on record. 6511. Yeah.
ତିନିଟା case
हाँ,
ଅଲଗା,
sir,
ତିନି ଜଣ
ଯୋଉଥିରେ ଫାଇଲ କରିଛନ୍ତି ଅନ୍ୟ କେସରେ ବି ଫାଇଲ କରୁଛନ୍ତି, you keep it. 15 December 2023.
Noblest.
Weekly list item number 1.
Item number 1 for 1 week time.
Why you mention this matter, and when the matter comes, you are taking adjournment?
Sir, I have collected some documents not available, sir.
Then why did you file the memo for listing them? It has come and mentioned the learned counsel for the petitioner seeks for an adjournment January रखी Yes.
Sir, ठीक है, sir, 15th.
You will give the date after verifying the diary. He will. Yes, next.
Item 2.
Item 2, may I please your lordship?
Yeah.
Already a petition under section 438 CRPC matter.
Why 438 matter has come to me?
My lord, earlier applications were disposed of by my lord.
Yes, there was a direction to surrender and you did not surrender. You have again come for anticipatory bail after 5 years.
No, my lord.
The direction was issued. It's a 2014 case. I asked you to surrender in 2018. Now you have come up again in 2023 for anticipatory bail. 394 case. Why anticipatory bail is to be granted to you? What is the change in the circumstances for changing my order?
My lord, here in this case, my lord.
Yes.
Initially, case registered on section 394.
Yes.
And subsequently turned to 395, my lord.
Yes.
So far as the allegation of the prosecution case, it is alleged that 4 persons inside the house of the informant and committed in the respect of some cash and gold, silver ornaments, my lord.
It's all right. Yes, then.
During course of investigation, my lord, on the basis of the confessional statement of the co-accused, my lord, the 2 co-accused were arrested. The present petitioner is arraigned and accused in this case, my lord. My lord, here in this case, my lord, charge sheet is submitted, preliminary charge sheet is submitted, where the petitioner's name is there. And after submission of charge sheet, my lord, the case is split up on 24/11/2022, my lord. 24/11/2022, my lord. And after issuing of NBW, I came to know this is a case pending against me, my lord.
24/11/2012. 22.
My lord.
Then who is the applicant in that ABLAPL 7529?
My name is Dipu alias Deepak Mahapatra, my lord. My name is Dipu alias Srikanta Mahapatra, my lord.
So what happened to the other co-accused persons?
They all are released on bail, my lord.
Already surrender and move for 11. Heard the learned counsel for the petitioner learned counsel for the state. It's a case where charge sheet has been submitted under section 395 IPC showing the petitioner as an absconder. Learned counsel for the petitioner submits that the co-accused persons have already been released on bail. And the petitioner may be permitted to surrender in the court below and move application for bail, then be disposed of expeditiously. Learned counsel for the state has no serious objection to such prayer. Considering the submission made by the learned counsel for the respective parties, this application is disposed of with observation that in case the petitioner surrenders before the court of learned SDGM Banki in connection with GR case number 39 of 2014.
39C, my lord.
39C.
My lord.
Of 2014, which arises out of Vaideswar PS case number 11 of 2014. Within a period of 4 weeks from today, the same shall be disposed of expeditiously, preferably in the first hour, so as to enable the petitioner to approach the higher court. The case record shall be made available and claim of parity with the co-accused person shall also be taken into account, disposed of. Yes.
Obligement.
Item 3.
pursuant to your lordship order dated 28/3/23
Yeah.
in IA number 256 of 23, the petitioner has deposited 3 lakhs of rupees in the court OPIDF. And for the rest amount of 26 lakhs 39,550, I have furnished the property security, my lord. No additional
This is a disposed of case.
Yes, my lord. This is a disposed of case. Earlier I have deposited 8 lakhs 50,000.
No, how much amount you have already deposited in cash?
In cash, my lord, 8 lakhs 50 plus 3 lakhs, 11 lakhs 50,000.
So where is the order? I mean to say.
Your lordship may kindly see the order dated 28/3/2023 in I number 256 of.
No, this matter came up last time on 1/8/2023.
Yes, my lord.
Thereafter, it has not come.
It was on the list, my lord. It could not.
Okay, so Mr. Patro. No, this is OPID Act matter. So have you not served a copy on Mr. Patro?
Yes, my lord. The lordship may keep it on next.
All right, just intimate Mr. Patro.
Yes, yes,
I'm keeping it on 15th. You want?
15th.
Okay. The learned counsel for the petitioner, Mr. Mahanti, Nirmal Chandra Mahanti is present. The non-appears for the state of Orissa. The matter may be taken off on the matter be listed on 15th of December 2023.
In the supplementary list.
Supplementary, yes, yes. Yes.
Item number 4.
Mr. Ravi Narayan Mahanti. No. Case diary is no? Okay, pass over.
Item 5.
May I please, my lord? My lord, offense number 20B2C 27/8/29 of NDPX Act, my lord. And my lord, custody since my lord 14/9/2020, my lord. And quantity of my lord 61 kg 800 grams.
DLAPL 7980/2022. କେବେଠୁ କଷ୍ଟଡିରେ ଅଛନ୍ତି?
Custody since 14/9/2020, my lord.
14/9/20
2020, my lord.
2020
20, my lord.
ଆଉ ଯାଇନଥିଲେ interim bill?
No, my lord.
Sure.
Sure.
Status report ମଗା ହେଇଛି? କେତେଟା ସାକ୍ଷୀ ହେଲେଣି? କିଛି ଇନଫରମେସନ ନାହିଁ ଆପଣ ପାଖରେ?
No.
ବୁଝିଦେଲେନି କୋଉଠିଆ କେସ୍?
ମାଲକାନଗିରି, my lord.
ଆଉ ବୁଝିଲେନି ଲୋକାଲ କାଉନସିଲ ରୁ ଯେ କଣ କେତେଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି ବୋଲି? ଦେଖନ୍ତୁ, the learned counsel for the petitioner submitted that the petitioner is in judicial custody since 14/9/2020 and he has received instruction that the petitioner has never been released on interim bail. In view of such submission, let a status report be called for. However, he has no instruction about the status of the stage of the trial. In view of such submission, let a status report be called for. While submitting the status report, the learned trial court shall indicate specifically as to whether the petitioner has been ever granted interim bail or not, and if so, whether he surrendered at right time after availing the same or not. Hala? So the baki usual order for the register judicial. Yes.
item number 4.
Item number 4 pass over age. Karibe kono na?
Yes, lordship. But in this case, lordship,
Just a minute.
Last occasion also directed me submitted the other co-accused person eligible. That is the copy of the net copy supplied to the standing.
Learned counsel for the petitioner submitted the petitioner is in judicial custody since one, so only 3 witnesses have been has received the copies of this also. Okay. If further submitted or some of the co-accused persons similarly situated have been released on bail and supply the same. Okay. On report asla report ta kete number flag G for Ganjam.
Yes,
Okay.
This court lordship 3 bail application.
With due respect, I am so that just a minute. 14 accused persons charge sheeted. Case was committed by the JMFC. 4/3/2022 charge was framed. Out of 19 witnesses, 3 witnesses have been examined. एड़ा को माओवादी केस की?
Yes, lordship.
हाँ. Offense so ଆଉ କେଇଟା କେସ୍ ଅଛି ଆପଣ ନାଁରେ?
ନାଇଁ ଗୋଟିଏ କେସ୍ ଥିଲା ଆଉ ସବୁଥିରେ ବେଲ୍ ହେଇ ସାରିଲାଣି ସବୁଥିରେ ବେଲ୍ ହେଇ ସାରିଲାଣି
କେତେଟା କେସ୍ ଅଛି ନା ସବୁଥିରେ ବେଲ୍ ହେଇଛି?
ମୋ ନାଁରେ 5ଟା କେସ୍ ଅଛି କମ୍ପ୍ରେହେନ୍ସିଭ୍ ଆଫିଡେଭିଟ୍ ଅଲରେଡି ଫାଇଲ୍ ଅଛି ଗୋଟେ ବରଗଡ଼ ପିଏସ୍ କେସ୍ ନମ୍ବର 6 of 2011 ବରଗଡ଼ ପିଏସ୍ କେସ୍ ନମ୍ବର 4 of 2017
ଏଇ କେସ୍ ରେ ଆପଣ କଷ୍ଟଡିରେ କେବେଠୁ ରହିଲେଣି?
2017 ରିମାଣ୍ଡରେ ମୁଁ ଆସିଛି କଷ୍ଟଡି ମୋ 2015 ରୁ ଏ କେସ୍ 2017 ରିମାଣ୍ଡରେ ମୁଁ ଆସିଛି except petitioner other co-accused person already been released of bail ଅଛି
ଆପଣଙ୍କର କମ୍ପ୍ରିହେନ୍ସିଭ୍ ଆଫିଡେଭିଟ୍ କୋଉଠି ଫାଇଲ୍ କରିଛନ୍ତି?
ଏଇଠି ଫାଇଲ୍ କରିଥିଲି ଅଛି
ଏଇ ଦେଖିଲ କମ୍ପ୍ରିହେନ୍ସିଭ୍ ଆଫିଡେଭିଟ୍ କଣ ଫାଇଲ୍ କରିଛନ୍ତି? Yes, Mr. Das. ସେ ଲୋକଟା ରହିଲାଣି 6 ବର୍ଷ ଆପଣ 3ଟା ସାକ୍ଷୀ କରିଛନ୍ତି ମାନେ 2 ବର୍ଷକୁ ଗୋଟେ ଲେଖା ଅଫେନ୍ସ କଣ ଏଇଗୁଡା ଏଇ ଚାର୍ଜରେ ତ ସବୁ 120B କଣ କଣ କରୁଥିଲେ ସେମାନେ ଆଲିଗେସନ କଣ
allegation is
पुलिस फोर्स को उड़ेइले फरे
କରିବ ବୋଲି
କିଛି ଇଞ୍ଜୁରି ଫିଞ୍ଜୁରି ହେଇଛି କା once while the police team organized the Adivasi festival there was heavy explosion on the road in between Swanso. Luckily all were saved as the explosion occurred prior to passing of the force. Following the explosion, a group of people from jungle gave slogan saying CPI, Maowadi Jindabad, Lal Salam Jindabad, police. Okay. In other cases are also similar in nature.
ଅଛି ସବୁ କେସ୍ ରିମାଣ୍ଡ ହେଇକି ଆସିଛି ଆଉ the fact is that
ଲୋକ କୋଡିଆର
ଭଞ୍ଜନଗର ଗଞ୍ଜାମ ଡିଷ୍ଟ୍ରିକ୍ଟର
Manoj Dandsena.
ଅଛି
Yes, Mr. Das, कौन कोई Heard the learned counsel for the petitioner, learned counsel for the state. Peruse the status report submitted by the learned trial court dated 30/10/2023, from which it appears that out of 19 charge sheet witnesses, 3 witnesses have been examined so far. The learned counsel for the petitioner submitted that the petitioner was taken on remand in this case in the year 2017. And in view of the slow progress of the trial, he may be granted bail. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that এইটাও ছাড়ি না পাঁচটা তো হ্যাঁ there are 4 criminal antecedents against the petitioner apart from the case in hand. The learned counsel for the petitioner has filed a comprehensive affidavit indicating the status of those cases. Se case order kon heichi apon?
सब बेल ହେଇଛନ୍ତି କିଛି କେସରେ ଟାର୍ଗେଟରେ ଅଛି ଟ୍ରାଏଲ ପାଇଁ
Ne trial katha chhadi.
सब बेल ହେଇଛି ୟାକୁ ହିଁ ଛାଡିକି ସବୁ ବେଲ ହେଇଛି
And the petitioner is stated to have been released on bail in those 4 cases. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody for about 6 years, and since during such span of time only 3 witnesses have been examined in the trial court, I am inclined to release the petitioner on bail. Shall appear before the learned trial court on each date when the case would be posted for trial, shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail allowed.
Item 6. May it please your lordships. Alleged offence under section 302, your lordships, and other barrage of offences.
CD available?
The date of
Aguru astile ki na first time?
again, I have earlier come, it was rejected by your lordships. See, that file has also come.
BLAPL number 917.
Lordships.
Don't
Lordships,
bother.
BLAPL number 7127 of 22.
Huh?
7127.
Wait. Let me see that order. Eyewitnesses injured Soumya Ranjan Panda, oral dying declaration of the deceased petitioner. Okay. So, one 2022. So, what is your custody date? Tell me one second.
Lordships. The date of incident is 25/1/2020. I have been taken on remand on 29/1/2022.
20
Again, date of incident.
No, incident chhad diyo.
Again, date of remand is 29/1/2022.
You have got other cases?
One case, your lordships, 399 or 402.
Okay. In this case, charge sheet submitted under section?
Charge sheet has been submitted, your lordships, under section 30.
Dekhi.
Again, 341.
Yes.
342. 294. 323. 332. 307. 302. 506.
Just a minute. 337.
332. 307.
307.
302. 506. 34 IPC.
What is the name of the deceased?
Deceased name, your lordship, is Kalakar Kshatriya.
Kalakar Kshatriya. And who is the injured?
Injured, your lordship, is one Rajesh Kumar Nag.
No, the earlier bail application was rejected basing on the statement of
one Panda.
So now what is the position
Your
in the
Lordships,
trial
in
court?
trial court, the witnesses have been examined. I have also filed the deposition copies.
How many witnesses?
11, Your Lordships. Till August, 11 witnesses have been examined. I have served copy.
What is the status report now?
Status report ଆଜ୍ଞା ଆସିନଥିବ
ଆସିନି?
ବୋଧେ ଆସିନି
So
7 8 ବେଳକୁ
se vital witnesses ଗୁଡାକ ହେଇଯାଇଛି?
examine ହେଇଯାଇଛନ୍ତି ଆଜ୍ଞା
କଣ କହିଲେ ସେମାନେ?
ଆଜ୍ଞା deposition I filed. If it is not there, I'll give another copy.
Deposition copy ଅଛି କି ଦେଖିଲେ ଫାଇଲ କରିଛନ୍ତି?
ମୁଁ 1/11 ରେ ଫାଇଲ କରିଥିଲି. If it is not
ଆପଣ
there,
ପାଇଛନ୍ତି?
ତାଙ୍କୁ ଅଛି.
Witness support କରୁଛନ୍ତି?
ହଁ witness ସେଥିରେ ଅଛି PW5 and 11 eye witnesses supported.
PW5 and PW11.
11. Witness supported. But apart from that, another other 10 eyewitnesses are also there to be examined.
PW5 is the
ନାଇଁ ସେ injured ଟା ହେଲାଣି ନା ନାଇଁ ସେ
ଆଜ୍ଞା injured
PW
PW11. That is the he's the last person.
ନାଇଁ ସାକ୍ଷୀ କାହିଁ ତ ଓକେ PW11 କଣ କୋଉ ଲାଇନ ଟା ପଢନ୍ତୁ କଣ ମାଡ ବିଷୟରେ ଯୋଉଠି
para 2 last line ରୁ ଆରମ୍ଭ the accused person had assaulted me by means of mera as a result of which I had sustained bleeding injury on the backside of my head. I then entered inside the room, but another worker, namely Krupa Chhatra, had been left outside the room. His father, namely Kalakar Chhatra, the deceased my lord, who was inside the room, had come out of the room with a view to save his son. The accused persons had dragged the deceased and had assaulted him severely. At that time, I, along with other workers, remained inside the room and had heard the
deceased scream
of the deceased, who, as crying, Morigali, out of fear, I didn't come out and had remained inside the room. I had informed the forest guard, namely Soumya Ranjan Panda, by using my mobile phone. The informant had...
It's all right. How many persons were there inside the room? Because there is obviously no specific overt act has been attributed against anyone. So it's a case of that the persons who were present in that room, they assaulted, and that is how the deceased was crying Marigali. And this man is an injured and he has seen this. So total number of accused persons in this case are
3 people, Your Lordships.
3. So what about the other 2?
They have been released on bail by Your Lordships.
Then how do you distinguish the case of this petitioner from those 2? If all of them have assaulted and 2 of them have been released on bail, yes. Have you handed over the copy of the bail order?
No, they have not.
This Sumit alias Dayasagar Kshatriya.
The injury, the cause of death is, Your Lordships, an injury on the knee. Your Lordship will find in the Gunasagar order.
Just a minute. Now, so oral dying declared deceased Kolakar Kshatriya was assaulted by 3. Acha, even dying declaration is also there.
That was witnessed by PW5, who has not stated anything, Your Lordship, but is there in the deposition.
Dying declaration में भी से जो deceased कहुची जे मते 3 जण मारले सेमाने होचंती पिटिशनर सुमित आउ गुणसागर नाग, and it is stated that they have assaulted him severely, dragged him and threw him by the side of the road.
In the 161
the postmortem report indicate deceased has sustained only 1 injury on the which is a penetrating injury of size so and so, and the cause of death was hypovolemic shock as a result of penetrating injury and so on. So okay.
Left.
So I mean no other bodily injuries on the statements of the stated to have been assaulted. Yes, future. Yes, Mr. Das. ये गोटे इंजुरी अछि आपण तीनटा जण ताको रिपीटेडली मारिचंदी कहउचंदी ए को अक्यूज गुडा को से जो मारथिले सिमिलर एलिगेशन they have been granted bail as it appears. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/1/2022. He has been charge sheeted under section 341, 342, 294, 323, 332, 307, 302, 506 by 34 of the Indian Penal Code. The earlier bail application of the petitioner in PLAPL number
7127
was rejected as per order dated 9/9/2022. The Land Council submitted that in the meantime, eyewitnesses have been examined and some of the co-accused persons have also been released on bail. He has produced the bail order copy of Sumit alias Dayasagar Kshatriya and in BLAPL number 11016 of 2022 and co-accused Gunasagar Nag in BLAPL number 917 of 2021. And the copies of the same are also been handed over to the Learned Council for the state. Learned Council for the state placed the evidence of two eyewitnesses, that is PW5 and PW11, from which it appears that the accused persons assaulted the deceased inside a room.
Your Lordship, it is not inside a room.
Outside the room, his father named who was inside the room.
Come out. These people, they hid inside the room. So there was no, basically they heard the shouts.
The
cries.
And they assaulted outside the and the deceased has also stated in the dying declaration about the participation of the petitioner. So also the co-accused Sumit alias Dayasagar Kshatriya and Gunasagar Nag. The Learned Council petitioner, on the other hand, submitted that the post-mortem report indicates that the deceased has sustained only one injury, that is on so 8 jagar in Mardujira. This is BLAPL number 917 of 2021. Hala? Then considering the submission made by the Learned Council for the respective parties, nature of accusation against the petitioner, the progress of the trial, the release of the co-accused persons on bail, and the period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. Allowed.
Pleasure.
Item 7.
May I please, my lordship? My lordship, it is a case under section 20B IIC NDPS Act. The petitioner is in custody since 21/7/2022. 62 kg ganja seized, my lordship, quantity. And police.
Just a minute. You have received the case diary, Mr. Das? 7 PLAPL 11694 2022. This is your first bail application or earlier rejected?
No, my lordship, this is my first bail application.
Okay, what is the date of custody?
Since 21/7/2022, my lordship.
21/7/2022. And what are the offences under which charge sheet submitted?
My lordship, under section 20B IIC of NDPS Act.
Okay, what is the stage of trial now?
My lordship, 3 witnesses so far deposed out of 11 witnesses.
3.
Again, yes, my lordship. 3 out of 11 witnesses.
You are a man from Bihar.
Yes,
So
my lord.
have you made the address verification? To do it whether the address is correct or not. And what about the criminal antecedent? That also you obtain. All right. You are Mr. S.K. Samim.
Yes, my lords.
All right. You are appearing from Bhadrak, na?
Yes, my lords.
All right. Heard Mr. S.K. Samim, the London Council from the Virtual High Court Bhadrak, who submitted that the petitioner is in judicial custody since 21/7/2022, and he has been charge sheeted under Section 20B2C of the NDPS Act. And out of 11 charge sheet witnesses, only 3 witnesses have been examined so far. The London Council for the State has received the case diary, but seeks some time to obtain instruction about the criminal antecedent, if any, against the petitioner, and further submits that since the petitioner is a man from state of Bihar, may be given some time to make necessary address verification. In view of such submission, list this case on such and such date. The Superintendent of Police of Gunpur shall make necessary communication with the Superintendent of Police of West Champaran District in the state of Bihar for ascertaining the correctness of the address furnished in the cause title of the bail application. Free copy of the order be handed over to the London Council for the state put up this matter on such and such date. Yes. Address verification and also the instruction about the criminal antecedent, if any.
Item 8.
May I please, Your Lordship? Last occasion on 12/10/2023, Your Lordship has directed to verify the securities filed by the petitioner for bail, my lord.
You are an outsider?
My lord. UP, my lord.
Okay. Yes, Mr. Das. कौन 30/6 पठेइछन ना नहीं? Then let it come next week. You pursue the matter because 30/6 মানে almost 6 months ହେଇଗଲାଣି. The London Council for the State seeks some further time to comply the order dated 36/2023. List this matter on 15th December 2023. Yes.
Oh, bless.
Item 9.
May I please, Your Lordship?
Yeah.
My lord, we filed a consent vakalatnama before the registry. Devasnandas and Associates, Lordship.
It is stated at the bar that the Mr. Devasnandas Achi. Okay, that Bhinama is now on record, so you can argue the matter, or you want adjournment?
Lordship, adjournment after vacation.
Okay. Mr. Devasnandas and his associates have filed power for the petitioner, which is taken on record. The name of the newly engaged counsel be reflected in the cause list henceforth in place of the earlier engaged counsel. Stop. London Council for the petitioner seeks for an adjournment, put up this matter. The case date by Chandi. Put up this matter in January as well. January? ସେଇ ଶୁକ୍ରବାରଟା ଆସିବ ଫାଷ୍ଟ ୱିକ୍ ପ୍ରଥମ ଶୁକ୍ରବାରଟାକୁ ଛାଡି ଦିଅନ୍ତୁ 5 ତାରିଖରେ ନା କଣ ଗୋଟେ ଶୁକ୍ରବାର ଅଛି ଜାନୁଆରୀ ହଁ ଏଇଟା ହଉଛି ଆସିବ 15 ତାରିଖରେ ଏଇଟା ନିଅ
Item 10.
May I please, on behalf of Mr. Singh Malad, may I permitted to place the last order order dated 21/7/2023. Lordship directed it to address verification.
Please wait.
I'm sorry.
Item number 10. ଗୋଟେ ହେଲେ ତ order ନାହିଁ କେତେଟା order ହେଲାଣି ଦିଟା order ହେଲାଣି ଗୋଟେ ହେଲେ order କରିନ କଣ ତମେ କହିବ ଦିଅ ସେ order file ଦିଅ ଗୋଟେ ହେଲା ସାଧନା ମୁଦୁଲି ସାଧନା ମୁଦୁଲି then another is Bhakta Harijan are found to be correct sadhana muduli
But they have also reminded they have not signed it. Let me follow up again.
21/7/2023. Lordship was direct.
okay last chance Learned Counsel for the state has produced the written instruction received from IIC Patangi Police Station dated 19/11/2023 to the effect that the two local sureties are found to be genuine and they also express their willingness to stand as sureties for the petitioner and the documents are also genuine. And there is nothing adverse against the local sureties. The report submitted by the IAC Patangi Police Station is taken on record. Stop. Learned Counsel for the state submitted that even though communication has been made by the Superintendent of Police Koraput to Superintendent of Police Bhojpur in state of Bihar for making necessary address verification as per the order of this court dated 21/7/2023, but response is still awaited. In view of such submission, lest this matter we commencing from 15th of December 2023. And counsel for the state shall obtain instruction in the meantime. Free copy of the order be handed over to the Learned Counsel for the state.
Item 11.
May I please your lordship? Lordship, on behalf of Mr. Sahu, may be permitted to move.
Yes. What modification you want?
Lordship, the modification is that, Lordship, while the trial court passed one condition that the petitioner shall appear on Monday in between 10 a.m. to 2 p.m. till conclusion.
No. I have granted you bail.
Yes, your lordship.
So
And
I have only imposed the condition 50,000 with two local sureties, and the other condition are to be imposed by the Learned Trial
Court.
Yes.
The Learned Trial Court has imposed one condition that the petitioner shall appear on Monday in between 10 a.m. to 2 p.m.
So for that, how can you file a modification application in this case? I have not imposed that condition.
No,
if
lordship.
the Learned Trial Court has imposed
Yes,
the
your
condition, a separate application is to maintainable.
Lordship, that separate application was filed.
Yes.
And it was rejected.
Yes.
After that, Lordship,
Rejected means by whom?
By the Learned Trial Court.
Where is that?
No.
This, Mr. Counsel, this is a disposed of bail application.
Yes, sir.
In this disposed of bail application, how such application would be maintainable?
Yes, sir, Lordship.
Against the order of rejection, you are to file the other proceeding is maintainable.
Yes, sir, Lordship.
For modification of the condition. I think that is CRLMA or something like that. So you withdraw this.
Yes, sir.
File. The learned counsel for the petitioner seeks permission to withdraw the application disposed of as withdrawn. Yes.
Oh, bless.
Item 12.
Yes, Mr. Mishra.
My lord. My lord, item 12, my lord, on earlier occasion, in BLAPL number 3353 of 2020. Again?
Race matter.
No, aguru asthila.
Kind order kind.
3353 of 21 and another is 3614 of 2022.
Deepak earlier bail application जोटा list रे अच्छी 3353 of 21 3353 of 21 re it was rejected and there was a direction to dispose of the trial within a period of 6 months.
My lord.
So that order was passed in 4/10/2021.
My lord.
So thereafter you have not approached this court.
No, my lord.
Okay, so now
this is the bail application, my lord. Charge has already been framed.
Yeah.
Charge was framed on, my lord, that is also reflected in the rejection order also. That is, my lord, 29/11/2022. The relevant portion of the rejection order, lordship may kindly peruse. That is page 15, last para, my lord. On 29/11/2022, charge for commission of offence punishable under section 20.
rejection order dated the
dated hela rejection order dated 1/2/2023.
को line ta kouchandi
last para, my lord.
29/11/2022.
Charge for commission of offence under punishable under section 20B2C/29 of the NDPS Act has been framed against the accused petitioners. So far, one witness has been examined. Again, tapore up to till August, my lord, total, my lord, 3 witnesses were, my lord, total 3 witnesses were examined.
Agur kichi order pass hi
किसी order है क्या है नहीं
हाँ
copy टा मुझे
आउ किसी मन order pass hi नहीं दियंदु all right, take down. The learned counsel for the petitioner submitted that last time 3353. Last time when the petitioner approached this court,
petitioners, my lord, both of them are there.
Acha. Petitioner nahi eta khali Deepak Kumar case thila jota agota e jo BLAPL number ta aschi jota
nahi arota it was disposed of by 3865 of 2021.
Order ta ardhire pass and the earlier the petitioner number 1 approached this court for bail in BLAPL number 3353 of 2021 while rejecting the said application as for order dated 4/10/2021. The London trial court was directed to expedite the framing of the charge and to conclude the trial within a period of 6 months from the date of framing of charge. And the petitioner was given liberty to renew the prayer for bail. Petition number 1 was given liberty to renew the prayer for bail if the trial is not concluded within the said period. It is submitted by the London trial court. Ebeka bail application 2023 submitted that the charge was framed on 29/11/2022 and he has instruction that by August 2023 only 3 witnesses have been examined. In view of such submission, let a status report be called for from the London trial court, that is Additional Session Judge cum Special Judge Gunpur in TR case number 32 of 2021. এই লোকটা কোটিকার?
My lord, he belongs to UP, my lord. Both.
So you make the address verification, Mr. Since both the petitioner.
ସିଏ ବି ମାଗି ଦିଅନ୍ତୁ, ସିଏ ବି କିଛି ନାହିଁ ଆଜ୍ଞା।
ନାଇଁ ତ ଏଇଟା ଗୋଟେ କଣ ଲେଖା ହେଇଛି ମାଲ୍ୟାମ ଲେଖା ହେଇଛି ଗୋଟେ କଣ ଖାଲି ନମ୍ବର 1 ଟା ଦେଖିଲେ
ନମ୍ବର 1 ଟା
ଏଟା କୋଉ ଷ୍ଟେଟ ଲେଖି ନାହାନ୍ତି କିଛି ଷ୍ଟେଟ?
ମୁଲତାନ ନଗର, ମାଲ୍ୟମ, both are of PS TP Nagar, district Meerut, Uttar Pradesh.
ଆଚ୍ଛା, both the petitioners are of state of Uttar Pradesh. May be given some time to make the to get the address verification. Let's say you usual order with the superintendent of police Raigada shall make necessary communication with the swan. So, hala, Meerut district or superintendent of police in the state of obtain that. And status report type mo kede. Yeah.
Copy of the deposition I am serving that lordship may
Copy of the
kindly.
deposition is
1 to
served
3.
on the Land and Council for the state, and put of this matter January. Huh?
Oblast.
Free copy of the order be handed over for the doctor's report. Then CA to be obtained also like them, है ना? CA and address verification. Council local जो जीवो set for that. Yes.
Item 13. Item 14.
May it please your lordship. The third round of the petitioner, the earlier two orders passed by the lordship.
कौन है दिया?
Second application, your lordship had granted him 3 months interim bail. He has surrendered. And in the meantime,
वर्तमान position कौन?
out of 25 witnesses, my lord, 4 witnesses have been examined.
Status report has been called for, or
No,
it is
ma'am.
coming for
3
the first.
witnesses I have given deposition. This is the 4th witness.
So you have instruction that 4 witnesses have been examined. What is the total number?
25.
When the last witness was examined?
12/10/2023.
12/10/2023.
2023.
Yes, Mr. Hard, the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 28/11/2019. And when he approached this court last time for bail in BLAPL number 6307 of 2021, he was granted interim bail for a period of 3 months, taking into account the delay in disposal of the case. And after availing the same, he surrendered at right time. ठीक समय surrender person. And now,
Annexure 2 is page 14 is the surrender.
and he has annexed the surrender certificate. Learned Counsel for the petitioner further submitted that out of 25 charge sheet witnesses, only 4 witnesses have been examined so far, and the last witness, that is PW4, was examined on 12/10/2023. He files the copy of the deposition of PW4, which is taken on record. And counsel for the state opposed the prayer for bail, considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, the progress of the trial so far, the conduct of the petitioner in complying with the earlier interim bail order granted by this court. I am inclined to release the petitioner on interim bail for a period of 3 months from the date of release. Disposed of. Who would have participated? Yes.
Item 15.
15, na?
That's a Passover.
Passover. Case diary achi, Mr. Huh? Next week rakhiwa. Acha, oh. Passover go. Acha. Next.
Item 16.
May please, your lordship. My lord, on the early, it is this bail application is before your lordship or third time your lordship. On the first bail application, my lord has directed to expedite the trial, and the second bail application, and your lordship has directed to make a surrender, and I have surrendered and release on bail. Surrender for specific time, interim bail, your lordship. They are told made a query, your lordship, that how many witnesses have been examined, and your lordship called for a status report for the from the concerned court below.
अच्छा और फ्रेश स्टेटस रिपोर्ट मगाइदला
Fresh status report
हां
order
कोन आसी लगी
सेटा आसी
एक घर ऑनलाइन 19 टारू 11 टा विटनेस ହେଇଛନ୍ତି
total my and the direction was given by your lordship way back in the year 2021.
in the meantime so and so service for now आगु जो जाइथिले इंटरिम बेल ठीक समय सरेंडर करथिले
my lord man surrender ठीक ठाक in time surrender करथिले
आगो बेल
12/1/2022 6967 of 2020
आगो बेल ऑर्डर टा का इंटरिम बेल ऑर्डर
सेटा इधर annexure 3 page 20 page 20
यो 6967 रे जाइथिले
Prior to this order, your lordship has directed to
ना
expedite
एटा
that.
एटा गोटे जाइथिले 13/1/22 रु 24/1/22 पर्यंत जाइथिले जोटा फाइल करजन
13/1/22 मासे ସେଇଦିନ ଆମେ ସରେଣ୍ଡର କରିଦେଇ ସେବେଠୁ କଷ୍ଟ
ଆପଣ ଯୋଉ 3 ମାସିଆ ବେଲ ଯାଇଥିଲେ କି
ନା ନା ଏତିକି ଯାହା ବେଲ ଯାଇଥିଲେ 13/1 ରୁ 24
this is an application which has been filed for grant of bail for first Shraddha ceremony. So
only that was your so that was the
and counsel for the petition submitted, he was released on interim bail for 10 days. The thore jaitile 10 days after hearing here. Okay, again Shraddha ceremony ପାଇଁ ଗଲେ So when you were taken into custody?
My lord, 9/4/2019, 9/4/2019.
Heard the land and counsel for the petitioner and counsel for the state. And counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 9/4/2019, and he was granted interim bail twice by this court for 10 days and then for the period from 13/1/2022 TO to 24/1/2022. And after availing the interim bail period, he has surrendered at right time. And in view of the slow progress of the trial, he may be granted interim bail. Period the status report dated 1/11/2023 submitted by the London Trial Court, from which it appears that out of 19 charge sheet witnesses, 11 witnesses have been examined. After hearing the London counsel for the state, the conduct of the petitioner in complying with the earlier interim bail orders and period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on interim bail for a period of 3 months. Disposed of. Yes, sir. Rest of the matter after lunch will take.
Item 202, my lords. Item 202.
Yes, Mr. Mahapatra.
Yes, my lord. My lord, the item 248 in weekly list. My lord, the accused in custody for last more than 8 years. My lord, the matter in fact was numbered in earlier 2018 matter, but unfortunately it was rejected on a wrong footing without hearing on merit. So we are compelled to file another application, which is now 7389 of 23. So can it be, my lord? Because
we'll see in the next week. It will see.
My lord, can it be in the supplementary of the specific
Okay,
day?
we'll see that. Just mark it. Yes.
Item 269. Marquee double murder case. 10 accused persons have been allowed on bail by your lordship. I am also making a similar prayer next week supplementary subject to your lordship convenience.
Mark for this.
26 ବେଶୀ କୋଏକ୍ୟୁଜ୍ ର 226 ସେ ବାକି ମର୍ଡର କେସର ମୋର ହଉଛି 226
My lord, another co-accused 13365 delisted 13365 same co-accused man.
No, that is not in the list.
Delisted man.
So you file a memo.
Already filed.
All right. Yes.
Item 224, my lord. Petition, my lord, interim bail, my lord. After surrender on 6/11, I filed a new petition, my lord. Custody since, my lord, 4/26 no 2019. After interim bail, my lord, petition surrender I have filed a fresh application, my lord.
All right, we'll consider, but I am mentioning, I'm going serially. Yes.
Lord, item number 56. Offense under section 373.
I'm going serially. Don't make mention.
Notice may be issued. Small prayer before Lordship. Item 56. Offense under section 3763. Notice may be issued.
56. There was a direction already to serve the extra copy. So there is an order on 19/10/2023 that you are to serve an extra copy which will be sent to IIC Deoghar police station for its service. You have not complied with. You again want that I should pass that type of order.
Sorry.
Yes.
My lord, item 202, my lords. Next Friday supplementary list, may I pray?
I'll see that. Yes, call the matter.
214 and 250, my lord.
Yes, call the matter serially. Yes.
Item 17.
Item 17, may I please, Your Lordship? The petitioner is in custody since 6/9/2020, alleged under Section 20B2C of NDPS Act. Your Lordship, it's the same case where the petitioner's son was getting married. I had filed an IA, and my lord had seeked for direction and also had asked me to file the bailer details, 2 local bailer details. I had filed all of it, but in the meanwhile, the marriage is over. My humble prayer is, my lord, that he was in the car. 2 co-accused have been released on bail in BLAPL 8680 of 2020, which is annexed in Annexure 3, page 19. I am not similarly placed because they were behind another car, 2 of them, and I was in the car where the contraband was seized, my lord. But I was not the driver of the vehicle. I was barely sitting in the car, and the contrabands were seized behind from the dicky. My lord, my only prayer before this honorable court is I am seeking bail on 3 grounds. That this earlier bail application number 5014 of 2021 was disposed of on 12.
Obtain instruction about that that
my lord,
address verification. So do it since the petitioner is a man from state of Uttar Pradesh. Learned counsel for the state seeks some time to obtain instruction as to whether the address furnished in the cause title of the bail application is correct or not. Put up this matter. Yes, next.
My lord, kindly earlier date, my lord.
Yes, we will see the date in the.
My lord, in August 2025, I had applied for interim bail, and it was earlier also rejected on 12/8/22.
Yes, next case.
Item 18.
Obliged, man.
May I please, lords? My lord, I am on the VC mode, my lord.
So you have not filed the surrender certificate?
My lord, my clerk is there, my lord. The surrender certificate is there.
Yes.
କେସ୍ଟା ଲିଷ୍ଟରେ ଥିଲା ବୋଲି ଦେଇନଥିଲି।
Yes.
My lord, last occasion in last BLAPL, that is 3033 of 2020.
Yes.
3033 of 2020, my lord says asked me to move after the examination of Gopal Behra. That is reflected at the last paragraph of the order, my lord.
What has happened?
Because he has shifted the deceased to the hospital. My lord, I have given the depositions, my lord. My lord, he was examined as PW3, my lord, in the meantime.
Yes.
But he has not supported, my lord.
Yes, Mr. Who are the other eyewitnesses?
Hello. PW2, PW6, PW4.
Are the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 2019 and are seated under section 302 5063 41/34 of the Indian Penal Code. When the petitioner earlier approached this court for bail in BLAPL number 3033 of 2020, as per order dated 25/1/2021, taking into account the eyewitness account of Gopal Behera, the bail application was rejected and liberty was granted to the petitioner to renew the prayer for bail after examination of the said eyewitness. Learned counsel submits that in the meantime, Gopal Behera has been examined as PW3 and he has not supported the prosecution case and declared hostile. He has filed the deposition copies of the witnesses examined in the learned trial court so far. Learned counsel for the state submitted that there is another eyewitness, namely Kaibalya Behera, and he is yet to be examined. Considering the submission made by the learned counsel for the respective parties, period of detention of the petitioner in judicial custody, progress of the trial so far, and the nature of evidence adduced in the trial court, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. The learned counsel for the petitioner filed the surrender certificate which is taken on record. Allowed.
Item 19.
May I please, Madam?
Yes.
20B2C of NDPS along with 25 and 29 of NDPS Act, my lord. The petition is in custody since 2/3/2022, my lord.
Agu reject ହେଇଛି?
Again, in BLAPL 5498 of 22, disposed upon 6/2/23 as infractions.
Okay.
Again. যেহেতু পুরোনা রিজেকশন অর্ডার ଥିଲା dispose of and in the meantime the petitioner is a local man, my lord. The quantity of 29 packets and out of 14 witnesses, 5 witnesses have been examined. And
the status report is dated 36/23.
My lord.
So in the meantime, almost another 5 months have passed.
Today morning, I have taken instruction from the concerned council. No witness have been examined.
No, ଏଠି ଏ ଯୋଉ status report ଆସିଛି ତା ଦେହରେ ଦେଖେଇଛି 14ଟା witness ରୁ 4ଟା witness ହେଇଛନ୍ତି ବୋଲି।
ନାଇଁ ଆଜ୍ଞା 5ଟା ହେଇଛି।
PW5 କେବେ ହେଇଛି?
PW5 ଆଜ୍ଞା ହେଇଛି 31/1/23।
31 ମାନେ ଗୁଡାଏ କି ନମ୍ବର? ହଁ।
Order reflect କରୁଛି out of 14 charges, 6 witnesses have been already examined.
But ଏଟା କୋଉ କେସ୍ ବାହାର କରିଛ?
BLAPL
2023
26 ର
case 15
just a minute. ଏଟା ଚିତ୍ରକୋଣ୍ଡା PS case number 98 ତ?
ଆଜ୍ଞା ଆଜ୍ଞା ଆଜ୍ଞା
ତାହେଲେ ରିପୋର୍ଟଟା ଦେଇଛନ୍ତି ସେସନ୍ ଜଜ୍ 36 ରେ 14 witnesses, 4 witnesses have been examined. And he has mentioned also that the case is expected to be disposed of by end of July 2023. And that is how he has posted. So you mean to say only
five
one
witness
five witness?
ସାର୍ଟିଫିକେଟ କପି
Rejection order indicate କରୁଛି 6ଟା.
6ଟା ଲେଖିଛନ୍ତି ପେଜ 17 ଲେଖିଛନ୍ତି 6ଟା
Sure. Right.
I pray interim bail for 3 months
Just
local
a
man.
minute, let the status report come. The period the status report dated 36/2023 of the London Session Judge cum Special Judge Malkangiri, in which it is mentioned that out of 14 charge sheet witnesses, 4 witnesses four witnesses are yet to be examined. 4 witnesses are yet to be examined by the prosecution, and the case is expected to be disposed of by July 23. The London counsel for the petitioner submitted that he has instruction that only 5 witnesses have been examined so far in the trial court. London counsel for the state, however, pointed out from the rejection order that 6 witnesses have been examined in view of the submission made by the London counsel for the respective parties. Let a fresh status report be called for from the London trial court so as to reach this court on or before such and such date. The London trial court shall specifically indicate how many witnesses have been examined so far in the trial court, how many witnesses have been declined, and why the case could not be disposed of by end of July 2023, even though it was said, it was mentioned like that in the earlier status report submitted to this court on dated 36/2023. Put up this matter on 15th of December 2023. Registered judicial shall intimate status report to be furnished by 13th of December 2023.
Okay.
Item 20.
My lord, the petitioner is in custody since last 5 years back. As per your lordship's direction, I have filed a comprehensive affidavit. Already I have served the copy.
Earlier rejected bail application.
Yes, ma'am. By my lord Justice Vinar Singh.
Acha. Now, what is the date of custody?
Since my lord, he was arrested 26.
26/6/2019. What are the offences under which charge sheet submitted?
467, 468, 471.
Just a minute. 467, 468. Yes. Then
471.
yes.
406. 420. 120B IPC. And Section 6 of OPID Act.
So earlier bail application number is BLAPL. Have you got the copy of that order?
BLPL 1429, BLPL 4586.
यार केते कोन ये जो what about this petitioner? This petitioner's name is Manoj Mahapatra.
Ismail.
So what is the bail application number of Manoj Mahapatra? How many bail application? One, two. Oh, the number of bail application has been filed. 3.
On the last bail application, my lord, this honorable court directed to conclude the trial within 6 months.
Where is that order? 9614 of 2022. এটা বার করলে
5822.
No, that was disposed of as withdrawn. 9614 of 2022. That was your last bail application.
That was for interim bail. That was
So wherein that direction was passed about 6 months disposal.
Already examined.
Out of 80 witnesses.
No, I think 84 years. And they are recalling that witnesses. Out of 4, 3 they are.
And your lordship direct on
ମୁଁ ଆପଣଙ୍କୁ କଣ କହିଲି ଆପଣ ଗୋଟେ ସବମିଶନ କଲେ 6 ମାସ ଭିତରେ ଟ୍ରାଏଲ ସାରିବାକୁ ଦିଆ ହେଇଥିଲା ସେଟା କୋଉ ବେଲ୍ ଆପ୍ଲିକେସନ ରେ କଣ ସବୁ ପ୍ରିପାରେସନ ହଉଛି ମୁଁ କିଛି ବୁଝିପାରୁନି
that is 3675 of 2022
ବାହାର କଲେ ସେଟା That was within 6 months it is to be concluded. That is in order dated 5/8/2022. Okay. So, Mr. You have examined only 4 witnesses, though there was a direction of this court to conclude it within 6 months as per order dated.
They have recalled the witnesses.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 26/6/2019 and he has been charge sheeted under section 467, 468, 471, 506, 420, 120B of the Indian Penal Code and section 6 of OPID Act. And when the petitioner approached this court for bail in BLAPL number 3675 of 2022, by the order dated 5/8/2022, while rejecting the application for bail, direction was given to the London Trial Court to expedite the trial and conclude the same within a period of 6 months from the date of receipt/production of the certified copy of the order.
Judge, I have a question.
The learned counsel for the
What is the charge? What happened? Judge, Your Honor, an objection. What happened here? Sir, can you answer my question, please? I'm here on court duty.
Here is it. However, Konala, submitted that he has received instruction that out of 80 charge sheet witnesses, 84, 4 witnesses have been examined, and the accused has filed recall petition to recall some of the witnesses.
In respect of 3 witnesses.
In respect of 3 witnesses. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody for more than 4 years, and since the order passed by this court in the last bail application to dispose of the trial within a period of 6 months has not been complied with, taking into account the slow progress of the trial, even though in view of the available material on record and the nature and gravity of the accusation, I am not inclined to release the petitioner on bail on merit, but the petitioner is directed to be released on interim bail for a period of 3 months. He will appear before the London trial court on his date when the case would be posted for trial. Yes. Objection. The London counsel. Yes.
Item number 3, my lord. My lord, I'm senior petitioner.
Non appears item 3 non appears to category. Yes.
Item 21.
Please, my lord.
Yes.
Offenses under 20B2C and 25 of NDPS Act. But this is the third round, my lord. In the last two occasions, on the first occasion, Lordship was pleased to direct the trial to be concluded within 6 months. Then again, I approached this honorable court. Lordship was pleased to grant interim bail for 3 months.
Where is that order?
Lord, those two orders, Lord, I am happy.
3 months. कौन हला था पर?
Lord, I have surrendered in time, Lord. In the meantime,
No. What is the present status of the case?
Lord, status, Lord, I have filed the deposition copies as well as the entire Lord, case diary, Lord. Till, Lord, 22nd 9/2023, 13 witnesses have been examined out of 18. Lord, and so far as these witnesses are
what is the total number of charge sheet witness?
18, my lord.
According to you, 13 have been examined.
13, my lord, as on 22/9/2023, and I have filed the up-to-date deposition copies.
Deposition copy. All those 13 will.
My lord, my lord.
It's a offense under 20B2C.
My lord.
So after 22/9/2023, no other witness has been examined.
But to that
or you have no instruction.
I have no instruction.
So let it come next week. The London Council for the and after availing the interim bail period, you surrender at right time.
My.
All right. The London Council for the petitioner submitted that when the petitioner was granted interim bail for a period of 3 months, as per order dated 24/11/2022, in BLAPL number 9231 of 2022, after availing the same, he surrendered at right time, and he has instruction that out of 18 charge sheet witnesses, 13 witnesses have been examined so far in the trial court, and PW13 was examined on 22/9/2023.
Lord, as on that date, Lord, she was examined.
PW13 was examined as no 13 was not examined. Ajan and he has received instruction that Ajan 22/9/2023 13 witnesses have been examined. Since in the meantime more than 2 months have passed, let a fresh status report be called for. बाकी यूजुअल कर दो स्टेटस रिपोर्ट 13 तारीख भीतर पहुंचेबे 15 तारीख मैटर लिस्ट हो. You have received the case diary, na?
Yes, I'll call for the case.
Land Council for the state has received the case diary.
Lordship, I haven't received. I'll get it by next week.
Case diary we obtained in the meantime, including CA also.
CA, my lordship.
Okay. He filed the bail orders which are earlier orders. Yes.
Item 22.
May I please your lordship?
Here. Yes, Mr. Mahapan.
The petitioner was arrested on 9/6/21, my lord. Offense is on section 302, reduced section
What is the date of custody?
9/6/21.
Okay. Charge sheet submitted under section
302, reduced section 34 and 120B of the Indian Penal Code, 25 and 27 Arms Act. Charge sheet was submitted on 31st July 21.
Earlier this petitioner approached this court?
No.
First time. So, what is the trial position?
Trial
Out of 51 charge sheet witnesses, 36 examined.
51 witnesses, charge sheet witnesses, out of which 36 has been examined, 13 witnesses has been declined.
13 declined. So it gone to 49. And have you supplied deposition copies?
दरकार नहीं मेरिट रे भी केस किछि नहीं. So far the accusation against the present petitioner is concerned, it is entire case is a circumstantial evidence. There is no direct evidence. It is said that the petitioner was implicated on the basis of the statement of one Rajat Vishwakarma. While he was in police custody, his statement under section 27 of the Evidence Act was recorded, and he uttered the name of the present petitioner. Apart from that, there is no other material.
Statement of co-accused
Rajat Vishwakarma.
Okay.
And he gave a recovery of a hammer
by that Rajat.
Hammer. He said that this petitioner is one of the participants in the alleged crime.
Yes, Mr.
Lords, in fact, there is no direct evidence, but there has been a procurement of a CCTV footage, Your Lordship, for which identification was also carried out, and that other co-accused was found out, Your Lordship.
CCTV,
my lords,
but not the petitioner.
Lords, that
Identify केही हेई पारलेनी CCTV रे दी जन को फोटो देखौची identity could not be established. That is the
So is it the only material is that confessional statement of co-accused in that 27 Evidence Act statement or anything else?
and this accused person has also made a statement under section 27, Your Lordship.
नहीं, ये देइथिला.
ये भी देइछ.
Yeah,
That has also led to discovery of
what was recovered at the instance of the petitioner?
Lords, no weapon of offense was recovered, Your Lordship. But other materials have been recovered.
आर कथा कन्फाइन करंतु सूरज कुमार झारो जो स्टेटमेंट रिकॉर्ड हला आपण कहउचंती
लॉर्डशिप
27 रे ता बेसिस रे किछि रिकवरी हला की?
perhaps my friend is not correct. किछि रिकवर नहीं कि किछि स्टेटमेंट भी रिकॉर्ड है.
No, statement has been recorded.
देखी दिन सूरज कुमार झा देखी ना
आगे.
The status report, Mr. Mahapatra, indicates that only the investigating officers are left out to be examined.
Yes,
Last invest.
Lordship, this is there. Interrogated the accused Suraj Kumar Jha, so and so, regarding his involvement in this case. During interrogation, accused Suraj Kumar Jha has confessed before witnesses
No, that is not. The 27 statement is separately recorded, and on that basis, if anything is recovered, then the seizure list is there and it is prepared. And so, is it there in that light or not?
just give me a-
ଲେଖା ହେଇଥିବା ଦରକାର 27
My
ଏଭିଡେନ୍ସ
lords, my
ଆକ୍ଟ ର
lords.
ଧାରା ଅନୁଯାୟୀ ଏଟା ଇଏ ହେଲା ରେକର୍ଡ ହେଲା।
Yes, that is there, Your Lordship. Confessional statement.
କଣ ହେଲା ରିକଭରି କଣ ହେଲା? ଖାଲି if nothing is recovered, only 27, then statement. Then if the confessional part goes, then what remains there? କଣ କହିଛି କି ମୁଁ ଚାଲନ୍ତୁ ଲୁଚେଇ ରଖିଛି, ଆପଣ ଚାଲନ୍ତୁ ମୁଁ ଦେଖେଇଦେବି ଏମିତି ଅଛି, ତାପରେ ନେଲା ତାଙ୍କୁ ଗୋଟେ ଜାଗାରୁ କଣ ଜିନିଷ ଯୋଉଟା ଆପଣଙ୍କର ଏଇ କେସ୍ ସଂକ୍ରାନ୍ତରେ ଇନକ୍ରିମିନେଟିଂ ଆର୍ଟିକଲ କିଛି ଜବତ କରିଲା ଏମିତି କିଛି ଅଛି?
He has stated that they both assaulted and they were holding a hammer and a gun, Your Lordship.
That is inadmissible in view of Section 25 of the Evidence Act. So that goes. Anything recovered, that is the only so much of information which leads to discovery of anything that will only relevant, otherwise nothing.
His wearing apparels and other aspects have been recovered, objects, but no bloodstains have been found in anything, Your Lordship.
Are the learned counsel for the Mr. Torochandra Mahapatra and senior advocate submitted that the petitioner is in judicial custody since 9/6/2021 and he has been charge sheeted under section 302 120B by 34 of the Indian Penal Code and section 25 and 27 of the Arms Act. And there is no direct evidence in the case, and the only material available against the petitioner is the confessional statement of co-accused. In the statement of co-accused Rajat Kumar Vishwakarma, recorded under section 27 of the Evidence Act, in portions of such statement, an hammer was recovered, and in the said statement, the said co-accused has implicated the petitioner. The land counsel for the petitioner further submits that the case has progressed a lot, and at this stage there is no chance of tampering or absconding, and therefore the bail application may be favorably considered. Review the status report submitted by the London Trial Court dated 30/10/2023, from which it appears that the prosecution has examined 34 witnesses and declined 14 witnesses out of 51 charge sheet witnesses, and investigating officers are yet to be examined. The London Council, the London Council for the petitioner submitted that one of the investigating officer is yet to be examined. London Council for the state, though submitted that there is CCTV footage, but Mr. Mahapatra submitted that the identity of the accused persons could not be found from the CCTV footage. Considering the submission made by the London Council for the respective parties, the nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, I'm inclined to release the petitioner on bail shall appear before the learned trial court on each date when the case would be posted for trial and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Allowed.
Before parting, may I say one thing?
Yeah.
There is another matter in which I am supposed to appear, that is item number 59. That
Yes.
cannot reach.
Yes.
Because your lordship noting
Election
the cause list is that election matter.
Right.
If it will reach, then it will be adjourned.
Okay. All right.
All right.
Item 23.
23. For if I may please your lordship, my lord, before submitting.
Item 24.
My lord, the petitioner's earlier bail application was dismissed as withdrawn, my lord. Withdrawn with liberty to file after charge sheet, my lord.
24th.
In the meantime, two co-accused persons, the principal co-accused persons, namely Raghunatha and Nakula, who committed murder, have been released on bail, my lord.
Where is that bail order?
That is, my lord, BLAPL number 9339 of 2022. 9339 2022. I would tell 6979.
Complete order टा नहीं तू दुई पेज हैं ऐसी आउ दी पेज करा
ଆଉ ଜଣେ ନକୁଳ ଦଣ୍ଡସେନା.
Why are you not filing the bail orders in which co-accused persons have been released on bail and give copies thereof to the London State Council so that he will verify? Your claim is parity ना? So parity तो ताऊ देबे सी देखिए verify same putting की नहीं आउ कौन? हला?
Next week, man.
Order upload ହେଇଥିବ ବାହାର କରି ଦେଇ ଦେବେ କଣ ଅସୁବିଧା ହଉଛି? The London Council for the you have received the case diary.
Yes, all documents.
London Council for the State submit that he has received the case diary. Land Council for the petitioner submit that two of the co-accused persons similarly situated have already been released on bail by this court, and he will supply the copies of the bail orders to the Land Council for the state by Monday. By Monday. Let the Land and Council for the State examine the claim of parity put up this matter on 15th December 2023. Yes.
Item 25.
My lord, item 25, my lord, with regard to the IIFL gold loan case, my lord. My lord, on last occasion, your lordship directed. My lord,
एटा बा आजी थिला से सप्लीमेंटरी सेही मैटर तो ए जो मन्नापुरम रो
This is Lalbagh, right?
IIFL.
गोटे मन्नापुरम रो नथिला
सेथरे सुप्रीम एथरे एटा न
हां तीन सेडा तीनटा सेही केस ना अन्य केस
एटा एटा आमो केस IIFL नो
Yes, Mannapuram is there, your
हां
lordship.
मन्नापुरम से आजी थिला
Same Lalbagh FIR number 294.
से अलगा केस ही तो
Okay, right, right.
25/8/2023 रे माय लॉर्ड योर लॉर्डशिप
आज पुलिस ऑफिसर सब आसीथिले गोटे तीनिटा अक्यूज्ड रो लाला अमृत रॉय देन लिलिमा आ गोटे कोन से दे हाजरा एमानकर आज बेल एप्लिकेशन थिला सुनानी पाई मु आपन पचारची सेही केस कि नै आपन कहउछन नै पीएस केस नंबर केते
294
को थाना रो
लालबाग
थाना रो
यस मैडम
हां 294 थिला तो एटा देखिले एटा
Yes, this is the same case, your
same
lordship.
case
I have the entire.
all right सेटा से दिन रखि दियो put up this matter on
My lord, in my case, last occasion, your lordship directed for State Council to verify the parity, my lord.
15
My lord, already gone one by Supreme Court and another by my
सेटा भी सेमाने भी कहिथिले 15 तारिख रे अछि सुनानी पई एकाडी सुनानी हबो put up this matter on 15th December 2022 yes along with से जो तीनटा केस तीनटा ने चारटा केस अछि है ना तादरु ए केसटा जोठी कर तारी संगे टैग करेबो तो जो एक केस नंबर देखि दबो जो लालबाग पीएस केस नंबर से आइटम संगे टैग करेबो नॉट दैट चारटा था कारण सेटा चारटा को सेपरेटली लिस्टेड हेछि गोटे 3 नंबर थिला गोटे 4 नंबर एम थिला जा संगे एटा सेठा ऑल राइट नेक्स्ट yes
Item 26.
May please your lordship, my lord. Here the petitioner custody 12/7/2022. Though status report was called for last occasion, and out of 22 witnesses, only one witness is examined. But here is a
just
case.
a minute receives so and so charge of the case has been framed one witness has been examined yes
But here is the case, my lord, basis of the implication, confessional statement of the co-accused. And my lord, in the meantime, my lord also granted bail one of this accused person who stands in similar footing. But I have some cases, my lord, of past criminal antiques. Expect that, my lord, there is no other legal material.
how many cases are there
six lordship
have you filed the comprehensive affidavit
Next, my lord, Friday.
the
Monday I will file.
Land and Council for the state has pointed out that there are as many as 6 criminal antecedents against the petitioner. Let the Land and Council for the petitioner obtain instruction in respect of such antecedents and file a comprehensive affidavit relating to the status of these cases. If in any case the petitioner has been released on bail, certified copy of the bail order shall be annexed to the comprehensive affidavit.
Download copy.
Yes, next.
Next Monday, my lord. Next Friday.
All right, 15 of December 2023. Yes.
Download copy.
Yes, next.
Item 27.
Mr. Unmesh Chandra Jena.
The lordship had directed them to file a comprehensive affidavit because he has 22 criminal antecedents in this.
He has not filed.
It's not.
अच्छा एटा 500 पर करता हूं
Lordship.
May please, my lord. Allegation is under section 302. Petitioner is in custody since.
Have you received the case diary?
No, it's case diary, but they've supplied the deposition copy.
No. Deposition copy is all right, but there may be some other material witnesses.
I'll
so better you get and We'll
I'll
take
get
up
it
this
next
matter
week.
next week.
Gotcha.
Learned Counsel for the state has received the deposition copies of some of the witnesses supplied by the Learned Counsel for the petitioner. However, he submits that he is yet to receive the case diary and instruction about the criminal antecedent. Place this matter on 15/12/2023.
Item 29.
May please last man. This is the second round of the petitioner my lord. Is in custody my lord. 31.
Case diary available?
CD is not there. Lordship had called for a status report also.
Okay.
Was as per instruction my lord. There is a I taken the one witness as exam in the constable.
No, it's already is not having the case diary. It's a offense under section
20B,
20B2C.
Earlier also it was
And you are in custody since when?
custody since 31/12/2019 my lord.
2019.
19 my lord.
Earlier granted interim bail.
No my lord.
First time you are?
Yes my lord. Earlier disposed rejected.
No, rejected all right. You
The
have
trial-
never been granted interim bail.
No, no.
What is your that one bail application number?
His number is my lord.
This man is Mangala.
BLAPL number 2964 of 2020.
Have you got the copy of that order with
Yes,
you?
my lord.
Pass on, let us see. There's a 6 months direction was there.
My lord.
Now, one witness has been examined. That is when that was examined.
Latest report, my lord. Let's check it.
Pass on, Paul.
The certificate.
No, this PW1 was examined on 24th September 21.
My lord. That time, that also last. Nothing else. This is the last.
How can it be known from this?
This is the certificate we were applying. That also
Contact.
put up to the last. And I have glance.
What is the total number of witnesses? As per charge sheet.
My lord, last occasion 6/11/2023. Last to put up the another accused.
6/11/23 रे order ହେଇଛି issue summons.
Summons. बस तापर ठरा किछ.
ओहो माने PW1 examine ହେଲା ପରେ କେମିତି ଜାଣିବୁ ଆମେ ସେଇଥିପାଇଁ status report ର ଆବଶ୍ୟକତା ଅଛି ବୁଝିପାରିଲେ ତ
My lord.
ଏ ଯୋଉ ଗୋଟିଏ order sheet ଦେଇଛନ୍ତି ଆପଣ 6/11/23 ରେ ଏଠି ଖାଲି ଲେଖା ହେଇଛି witness କୁ ସମନ କରାଯାଉ ତ ସେଇ order sheet ରୁ କିଛି ଜଣା ପଡୁନି ଯେ ଏକ ପରେ एकटा ହେଇଥିଲା 24/9/2021 ତାପରେ ଆଉ ହେଇଛନ୍ତି କି ନାଇଁ କିଛି ଜଣା ପଡୁନି ହେଲା ଆପଣ ଏଣ୍ଟାयर ଅର୍ଡର ସିଟ୍ ପ୍ରଡ୍ୟୁସ କରିଥାନ୍ତେ ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ ଆପଣ ଗୋଟେ ଲାଷ୍ଟ ଅର୍ଡର ସିଟ୍ ପ୍ରଡ୍ୟୁସ କରୁଛନ୍ତି ସେଥିରୁ କିଛି ଜଣା ପଡୁନି ଲେଖନ୍ତୁ ଦି Learned Counsel for the petitioner submitted that the petitioner earlier approached this court in BLAPL number 2964 of 2020 and while rejecting the said bail application as per order dated 25/1/2021, the Learned Trial Court was directed to conclude the trial within a period of 6 months from the date of receipt of the order, and the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the aforesaid period. The Learned Counsel further submits that only one witness has been examined on 24th September 2021 and he has produced the deposition copy of the PW1 and order sheet dated 6/11/2023. From the order sheet, it doesn't appear how many witnesses have been examined so far in the trial court. Let the let a status report be called for, but usual order kar debe, hai so as to reach this court honor before so and so matter to be placed on 15th December 2023. You obtain the case diary and instruction about the criminal antecedent in the meantime.
Lordship.
These are taken on record.
Please, sir.
Item 30.
30, my lord, pray for an adjournment, my lord, next week. Okay. You have received the case diary, Mr.
Yes, case diary.
The Learned Counsel for the state submits that he has received the case diary. Learned Counsel for the petitioner seeks for an adjournment.
Item 31.
Rest of the matter next week, yes.
Status report is continued.
31 status report movie.
15 কাছে 15 মানে 15
সবগুলা 15 আছে। Yes.
Witness copy টা out of 34 3 witness has been
Requisition copy of some witnesses file taken on record, that is in item number 31.
Your Lordship, item 206, only interim prayer, interim bail.
We'll take up this matter next week and
Obliged to this.
yes. Dear Khata dear.
Lordship, mention
Supplementary list. Item number 14.
Yes, Mr. Muslim.
Should I? Mirror paragraph 115 of PW1. At page 95.
This relate to part 3A.
3A.
No, part 3A, you have already placed, I think, the PW3's evidence in that respect.
PW3's evidence.
Returning officer. This is PW1.
Yes.
So,
a comparison ହେଇଛି.
No, if it is correctly, if I remember, so their case is that it is not in proper form, but they mean to say that if the
Totally blank.
Totally blank, then the second part of number 2 to 8 has been totally deleted.
3 to 8, 9.
3 to 9. In fact, 9 is there.
Yes.
But admittedly, the second line has been deleted because the answer has been given as no.
Yes.
If it would have been yes, then there was any necessity of filling of the second line. So that is all.
Yes.
So this evidence, what he has further stated that
ଏଇଥିରେ comparison ଟା ହେଇଛି. According to me,
In election petition in paragraph 7A in page 7, 12th line from the top, I have mentioned that the paragraph 3A of the nomination paper filed by the respondent has not been filled up by the respondent. According to me, he has not filled up part 3A at all in his nomination paper in form 2B. Part 3A of the nomination paper filed by the respondent is not in proper format as prescribed by the Election Commission of India. My counsel can say what are the information required to be given by a candidate in his nomination paper in form 2B under its part 3A, which the respondent has not furnished. My legal advisor can only say what are the defects while filling up part 3A of the nomination paper in form 2B by the respondent. I cannot say whether I have mentioned in my election petition the details of the information required to be given by the respondent in his nomination paper in form 2B.
No, Mr. Mishra, what I say that that nomination paper is before us, right?
Yes.
It is an admitted thing that there is the deletion is there in the second
part.
माने 3 टू आरंभ करी 8 पर्यंत सेकंड लाइन टा डिलीट ହେଇଛି
आज्ञा
काहेकि डिलीट ହେଇଛି आपण कहउचंती जेहेतु जदी येस हेई थांता ताले लेखि थांते फर्स्ट लाइन टारो आंसर जदी येस हेई थांता लेखि थांते सेकंड लाइन टा जेहेतु फर्स्ट लाइन रो आंसर हैला नो तेणु यार माने ये रहिले भी यार किछि रेलेवेंसी नाही सो that is an admitted fact. Now you are to argue, according to me, that you are to argue that whether this deletion which has been done is at all relevant or not, or it is a deletion of such a nature which is substantial in nature, or it is no way relevant. That is the evidence to अछि जहा से कहिछि आपण evidence रे आसीछि कोन हेइछि.
My contention before your lordship is whatever parts have been deleted, that is not relevant at all.
That you argue it is not not necessary to for the witness has just seen that whatever he has stated that eta rahi
no, what is material why I am placing? He avoids to answer and places reliance on the statement of his counsel.
It's all right. That is there.
My lord.
He has.
What I beg to in place before your lordship that part of his statement has not been complied with in course of evidence.
What?
So जो से कहले जे मो एडवोकेट कहि परिबे मिलन बाबू गोपाल बाबू आ जने एडवोकेट तीन जन सेही तीन जन ही कहि परिबे मु कहि परिबे नाही.
That is there.
So no, if it is there, contention before your lordship is he has not stated anything material to the allegations contained in paragraph 150.
Right, I am noting of. There is no necessity of placing this. Yes. Yes.
Secondly,
yes,
I put him in cross-examination. Just look to your verification. In verification, he says whatever I have stated in the election petition is according to my personal knowledge. Whereas in evidence he said that my advocates can say about the allegations made and I cannot say.
Yes. Next point.
It is a fact that in my verification as well as in affidavit in my election petition, so far as paragraph 7A of the election petition is concerned, I have mentioned that the particulars of illegalities, irregularities as alleged in this said paragraph are based on my personal knowledge.
Noted down, noted down.
My lord.
Yes, next.
Then, my lord,
Yes, 3A is over. Next.
ନାଇଁ ଖାଲି ଆଉ ଗୋଟାଏ ସେଇଥିରେ ଲେଖନ୍ତୁ ସେ ଯୋଉ କହୁଛନ୍ତି according to me he has not filled up part 3A at all. That's a falsehood.
False statement.
The document is before your lordship. Lordship can verify it.
According to you, that in fact it has been filled up, whatever relevant that has been filled up. And the omission is the irrelevant.
Irrelevant. Whereas according to him, it is not at all filled up.
Oh, that I noted down.
Making a total false statement before the court on oath.
Right, right. That's right. But one thing here, I just want an answer from you. Like the other part of the nomination paper, where it is mentioned that score out or so and so which is not applicable, is there anything in part 3A like that?
Yes.
Please show me that. Then how
Like
can
3A
if that is not there, how can you score out the
সেটা আছে if yes.
No, no.
If yes.
If yes,
ସେଇଟା ଅଛି
ସେଠି ଯୋଉଟା
କିନ୍ତୁ
ଆପଣଙ୍କର
ସେଠି
ଥିଲା
ଯୋଉ ଅଛି ସ୍କୋର ଆଉଟ୍ କରିଦିଅ
ମୋର ଆନ୍ସର ଟା ମୁଁ ଆପଣଙ୍କୁ କହୁଛି ମୋର କ୍ୱେରି ଟା ହଉଛି
ନାଇଁ ସେମିତିଆ ନାହିଁ
ହଁ So even
କିନ୍ତୁ
though
ଏଇ ଯୋଉ ଆଉ
just
ଟିକେ ସେଇଠି
let us sum up. So even though there is no mention by the authority to score out or delete the second line of part 3A of the nomination paper, you have deleted on your own on the ground that it is not relevant.
relevant.
Right? So next question would be, just listen and then answer. Next question would be that if such an option has not been conferred on you, who has authorized the applicant to delete that portion?
As it is not relevant for him, he has deleted.
You said in that line it's all right, score out, delete. But here is a specific part.
Without mention also, I could have struck it out.
Right. No.
If I could have struck it out.
There is no question of struck it out. Once you mention it is no.
No.
Then there is no question of filling the second line.
Therefore, irrespective instead of filling not filling of the second line, I have deleted it. That is the case.
Again, I'm asking you my query to you that there you say that there was an option given that you score it out. And according to you,
here there is no option given.
Score out means delete, so I have deleted. What about part 3A when there is no such discretion or no such authority has been given to the concerned candidate to delete it? It is to be why if he has deleted it, whether
What will be the
consequence.
My lord. First of all, my contention before your lordship is, it is not his case. Not in the pleading, not in the evidence on affidavit, not in his chief.
कौन टा केस में
ଏଇ ଯୋଉ କଥାଟା ଯେ ସିଏ ଆପଣ ପଚାରୁଛନ୍ତି,
ଓହୋ ଆଚ୍ଛା ଆଚ୍ଛା ଓ ମୁଁ ପଚାରୁଛି
ହଁ ଆପଣ ଯୋଉ କଥାଟା ପଚାରୁଛନ୍ତି,
that is not in the
that is not in his
yes,
case.
yes.
ତିନିଟା ଯାକରେ ନାହିଁ, not in the pleading, evidence on affidavit or examination in chief.
So according to you, there is no pleading and nothing in the evidence on affidavit or in the examination in chief that any option was available to the contestant to score out or delete any line of part 3A of the nomination paper.
Right.
Okay, all right.
Rather, he is consistently speaking both the three things that he has not said. And then under the rest of the paragraphs,
leave that, Mr. That is the main thing, you said.
ନାଇଁ ଆଉ ଗୋଟେ ଅଛି,
Yes.
ଆଉ ଗୋଟେ part ଅଛି. I want to place it before your lordship for your lordship's kind consideration. Part 3A under item number 1 to 9. He has given evidence in his subsequent paragraph. I am placing those portions, material portions only. Part 3A of my nomination paper in Form 2B, marked as Exhibit E2, F2, G3, H3, are in prescribed form. Page 96 की देखो. It is a fact that while filling up item number 1, part 3A of Form 2B, which requires a candidate to mention about his conviction in any offense under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the RP Act 1951, and whether he has been convicted of any offense or offenses for which he has been sentenced to imprisonment for 2 years or more, myself as well as the respondent have put tick mark over the word no. Moving no,
The same thing, though.
I have scored out the word yes in my nomination paper, whereas the respondent has left the word yes as such. Submission to your lordship is that if I put no, the tick marked no, then answering to the next person is not necessary at all.
That there is absolutely no dispute.
Then your lordship may kindly come to, and this is the answer to item number 1. Then kindly come to item number 2. Next paragraph. It is a fact that while filing up item number 2 of part 3A of Form 2B, which requires a candidate to disclose as to whether he is holding any office of profit under the government of India or state government or not. If yes, the details of the office held, I have put a tick mark over the words no and scored out the word yes and mentioned not applicable against the second line. Whereas the respondent has simply mentioned no against the item number 2 of part 3A and further mentioned NA against the second line. So he has complied with. It is a fact that against item number 3 of part 3A of part 2B, where the candidate is required to furnish information as to whether he has been declared insolvent by any court or not, in my nomination paper I have scored out the word yes and put tick mark over the word no. Your Lordship got it? My Lord. And against the second line of item number 3, I have mentioned not applicable. The respondent has simply mentioned no against item number 3 of part 3A of form 2B in the first line, and the second line of item number 3 is a total missing in his nomination paper.
That is his case.
Deleted.
That is his case.
My
In all the columns, same thing has happened.
My Lord.
That the second line is missing. According to him, that the missing of the second line means it is not in prescribed.
Not in
That's
prescribed.
all. Yes.
What I beg to submit first,
Yes.
this is not pleaded in his pleading.
I have noted down.
My Lord. 4, 5, 6.
Same thing.
Same thing.
Cross-examine କରିଛନ୍ତି on some things which were beyond pleadings. That is why we had objected.
ସେଟା କହିବେ ଆପଣଙ୍କ ଟାଇମ ଆସିଲେ କହିବେ.
You are just wasting this honorable
Just-
court's time by
No, no.
going on things which are not there in the pleadings. It is not a case also.
No. Just 3 ବର୍ତ୍ତମାନ ୟାର ଗୋଟେ particular item ଉପରେ part 3A ଆପଣଙ୍କର averment ଥିଲା pleading ଥିଲା ଯେ part 3A is not in prescribed form, right?
Yes.
ଏବଂ
It is not filled up at all.
ଆଚ୍ଛା
Has not been filled up, and my lord,
No.
ticking yes, no, एगुरा हमारा case ही नहीं.
No.
So,
Question
I'm
is
not
that-
saying he's an insolvent.
Question is that what he wants to say that these whatever in the manner it has been filed by the respondent, it cannot be said that it is not in proper form because what was not relevant that has been deleted. Question is that whether it is permissible for him
Or
to
not.
delete or not. That is the only thing. If it is not permissible, matter is different. If it is permissible,
And whether it is available in your pleading or not.
all right.
ତାଙ୍କ ପ୍ଲିଡିଂ ରେ ଅଛି କି ନାହିଁ ଏବଂ ଯଦି ଅଛି ତାହେଲେ ଡିଲିଟ କରିବାଟା ମୋ ପାଇଁ ପରମିସିବୁଲ କି ନାହିଁ ଏଇ ଦିଟା କଥା ଆପଣ ଡିସାଇଡ କରିବେ.
Second line ବିଷୟରେ ସେମିତି ପ୍ଲିଡିଂ ରେ କିଛି କହିନା
କିଛି ନାହିଁ.
ଖାଲି କହିଦେଇଛନ୍ତି ଗୋଟେ ଲାଇନ ଯେ that is not in prescribed form. Okay.
That is not filled up at all.
Just let us see that one line. ଏଇଟା ବାହାର କଲେ.
That is not filled up at all.
Let us see that one line from the election petition.
Page 7, my lord.
Just a minute. Page 7.
Page 7.
3 year जोड़ा पूरा specific पड़े. I have underlined it. Yes, sir. 3A of the nomination paper filed by the respondent has not been filled up by the respondent. This is number 1. The columns of part 3A of the nomination paper has been left blank, and the columns number 3 to 9 are also not in prescribed form to be. So what they mean to say that since not stated in that way, but what they mean to see that this is not in prescribed form. Obviously 3 to 9 every column has 2 lines.
Allegation with the last time we could not in prescribed form. But my lord, may come to exhibit 36. His evidence on affidavit at page 5.
ଆଉ ଟିକେ ଅଧିକା କିନ୍ କହିଛନ୍ତି
Second, same repetition.
Hmm.
After exhibiting the documents before my law, they are again stating falsehood that the columns.
So that I have marked. Whatever you columns have been left, mane not filled up. That you have argued in while arguing PW3's evidence.
Minor.
I have noted down that was not correct because
Petition consistently saying it has not been filled up.
not so. In fact, this particular line, the first line, has not been filled up by the respondent. It means that it has not at all been filled up.
Minor.
So,
entire allegation with respect to
part 3, right? You are right. But
It was a false allegation.
all right, part 3A of the nomination paper filed by the respondent has not been filled up. It means has not at all been filled up.
Minor.
And they goes further to say that columns of the part 3A has been left blank and columns of so and so has been null. So, and these particular lines are also appearing in the evidence on affidavit.
Evidence cross examination ରେ ସେ କହୁଛନ୍ତି part 3A he has not filled up part 3A at all.
Evidence.
କାହା evidence ରେ କହୁଛନ୍ତି
PW1
ଓ ଏଇ ଯୋଉଟା ପଢିଟା ଏଇ ସେଟା ବାହାର କଲା ଆଉଥରେ ସେ ଯୋଉ 96 ତ ନା କୋଉ ପେଜ ରେ ଦେଖଉଥିଲେ
page 95 to 101
ନାଇଁ ନାଇଁ ସେ ଯୋଉ ଲାଇନ ଟା ଖାଲି ଦେଖନ୍ତୁ
relevant ଟା ସେଇ 95 ରେ ଅଛି
Top ଗୋଟେ line.
1 2 3 4th line ରେ.
According to me,
Mine.
he has not filled up part 3A at all in his nomination.
Mine.
That
ଏଇଟା ଟିକେ kindly note କର.
wait.
Yes, 5.
Wait. Para 115, 1, 2, 3, 4 line.
From top.
এই টাইপର କରିକି ଦେବେ ସେ ଯୋଉ written note.
ଆଜ୍ଞା.
According to me, according to you, if you just give a glance at the documents itself, it would show that it is a false statement.
It is a false statement.
Carry on.
ତାଙ୍କ evidence on affidavit ଟା ଟିକେ ଦେଖନ୍ତୁ.
Exhibit 36 minor.
Exhibit 36 କୁ ଆସନ୍ତୁ.
Page 5.
କଣ ଏମିତି ସ୍ପିଡ ରେ ଚଲଉଛି
ନାଇଁ evidence on affidavit. ନାଇଁ evidence on affidavit.
Evidence of affidavit also 2 parts. Your written evidence on affidavit ରେ ଅଛି ବୋଲି ଆମେ
just
paragraph 9 1 2 3 4 5 5 line from the bottom.
wait এটা annexure 36
My lord got it.
ଟିକେ exhibit କାହିଁ ସେଟା 35 ଯାଏ ଅଛି 36 କୋଡା ହେଲା back kar evidence affidavit separate thibo এটা বার কর পিটিশন ডিপোজিশন प्रथम को नियो yes evidence affidavit
Paragraph 9 से 5 नंबर पेज रो 1 2 3 4 पंचम लाइन फ्रॉम द बॉटम लाइन
the part 3A of the nomination papers filed by the respondent have not been filled up by the respondent. The columns of part 3A of the nomination paper have been left blank. Columns from so and so are not in prescribed form. The respondent has filed his nomination papers prepared, but under that is not. So, 18 lines. 18 line ye maro.
evidence and affidavit देती है examination and secret time कोई पक्का नहीं कर कोई
Evidence on affidavit markage ke exhibit
36
exhibit 36
paragraph 9
page hochi 5 na
my lord
para 9
page 5 ro 5th line from the bottom
5th line from bottom part 3A the nomination ... prescribed form 2B. Yes, Mr. Mishra.
Then, my lord, part 3A, with respect to part 3A, item number 2, 3, 4, 5, 6, 7, 8, and 9.
9 is in proper form. So 9 there is no problem. Only 3 to 8, the second line has been deleted. That is why, according to them, that it is not in proper form.
Therefore, their averment with respect to 3 to 9 is not
It's
correct.
not correct.
Not
It's
correct.
rather, it's a, according to it's a false statement.
False statement.
Okay.
So that you can note.
Not yes.
Then, my lord, at the end of part 3A of Form 2B, a candidate has to put his signature and mention about the place and date. In all the 4 sets of nomination papers filed by the respondent in Form 2B at the end of part 3A, the respondent has put his signature and mentioned Cuttack against a place and 2/4/2019 against the date.
There is no dispute about
There is no dispute.
Leave it there. Yes, next.
କିନ୍ତୁ ତାଙ୍କ ପର୍ସନରେ ଆମେ କହୁଛୁ it is a fact ଯୋଉଟା କହୁଛନ୍ତି it is a fact that in my nomination paper marked exhibit G3 though at the end of part 3A I have put my signature but I have left blank the place and the date. All my nomination papers including G3 have been accepted by the returning officer as valid.
Okay. Yes, next.
Then, my lord, paragraph 116 relates to his statement that he is having a subsisting contract with NTPC.
He has stated, he has mentioned it no.
No.
Okay.
But in affidavit in Form 26,
SISMA election and the challenge, my lords, they have cross-examined me.
Ita kahar kahatar ko. Oh, appan ko no, leave it. Leave that. Yes, next. Yes. Leave that. Don't waste time. Yes. Yes. No. Please don't. Leave it.
ନାଇଁ ନାଇଁ ମୁଁ ଆପଣଙ୍କ ଯୋଉ ପ୍ରଶ୍ନ ପଚାରିଲି
It's all right. Don't argue on the nomination paper of the that is not in the question here. I should not waste my time there. Yes. Please come to the next. Yes. No. Please come. Yes. Next. No. Leave it. Yes.
where the nomination paper at a to court.
Yeah.
Where the nomination paper which has been filed by you and submitted are available and how a candidate can get the same. His answer is it is available with the returning officer and there is an application form which is required to be filled up by the candidate and submitted before the returning officer indicating therein how many sets of nomination papers he is required to file. The nomination papers can be given to the candidate or to his authorized representative after mentioning the same in a register by signing the same. এই ଯୋଉ ସେ କହିଛନ୍ତି ମୋ ପାଖରେ ସେ ଆପ୍ଲିକେସନ ଫର୍ମାଟ ଟା ଅଛି।
Yes, all right. Next.
ନାଇଁ ସେ ଗୋଟାଏ ମୁଁ ଖାଲି ଦେଖେଇବାକୁ ଚାହୁଁଛି ଯେ ସେ କହିଛନ୍ତି ନମିନେସନ ପେପର ଅଛି ମୁଁ ଫାଇଲ କରିପାରିବି।
Okay.
ନାହିଁ ସେଗୁଡା
Next. Yes, next.
Then paragraph 118.
Yes.
It is not a fact that the nomination paper filed by the respondent was rightly accepted by the returning officer as it contains all the required information. So far as the respondent is concerned, it was duly proposed by the elector of 90 Baravati Kotak Assembly constituency. The returning officer, according to me, should not have accepted the nomination papers of the respondent in the form in it, which it were filed. Then, my lord, say repeat କରୁଛନ୍ତି so moto deleted part 2.
Leave it. Yes, next.
Then I beg to draw your lordship kind attention to paragraph 119 and 127. 119 ରେ କହୁଛନ୍ତି I cannot say exactly as to how many candidates filed the nomination ଏବଂ କେତେ set nomination file ହେଇଥିଲା.
Yes.
I have not downloaded the nomination papers and affidavits of other candidates except respondent who had filed a nomination paper for contesting the election in question, as I did not find it necessary for the purpose of filing the election petition.
Yes, next.
Then paragraph 127 at page 113 bottom.
Yes.
I can file the application form. He has not filed.
Yes.
Not exhibit. This is all about his.
All right. Next.
The next I will go to on the next sitting. I will place my submissions and citations.
On which? On what?
7A.
And 7A.
And I propose to conclude even 7B before vacation.
That's good. So do it, please. So would we have today sufficient time, Mr. Mishra? Can you proceed further on 7B?
No, I can only indicate the relevant provisions to your lordship.
About what? Which relevant?
କୋଉ provision ଅନୁସାରେ ଆପଣ ଦେଖିବେ ଖାଲି ମୁଁ କହିଦେବି ଆପଣ ଟିକ୍ ମାର୍କ କରିଦେବେ ସେଇଟା କାଇଁ ଆଉ ପଛକୁ ରଖିବା ଏଇଠି ମୁଁ ସମୟ ଅଛି ସାରି ଦଉଛି. Article 173. Then A, B, C both. Total Article 173. Article 191, which relates to 73 relates to qualification.
Article 173 you said.
Yes, ma'am.
Then 191.
191 relates to disqualification.
Yes.
Then RP Act Part 2, Section 5, Section 8, Section 8A, capital A, my lord.
Yes, yes.
Section 9, Section 9, capital A, Section 10, Section 10, capital A, then, my lord, Section 32, Section 33, then Section 34, deposit, Section 36, scrutiny, then, my lord, Section 83, presentation and contents of election petition, Section 100, grounds for declaring election to be void, ଏଥିରେ ଟିକେ ମାର୍କ କରନ୍ତୁ subsection 1
100 ର ତ
100
ହଁ
and clause D
D capital na small
D
small d yes
ଆଉ clause IV Roman
IV ହଁ
by any non-compliance with the provisions of the Constitution of this Act or of any rules or orders made under this Act. The High Court shall declare the election of the returned candidate to be void. D ର
D ଆପଣ Roman 4
section 100 ର
ହଁ
1 ଟା ଦେଖନ୍ତୁ subject to the provisions of subsection 2 if the High Court is of the opinion A B C ଛାଡ଼ି ଦିଅନ୍ତୁ D ଟାକୁ ସାର୍ ଦେଖ
improper acceptance ଯୋଉଟା ଅଛି
ନାଇଁ that the result of the election
result of the election so far as is concerned has been materially affected
material affected ତାପରେ IV by any non-compliance with the provisions of the Constitution of any or of this Act or any rules made thereon.
So here it is what is relevant is 101 D Roman 1 and Roman 4.
Roman 4.
Because their case is that it was a case of improper acceptance.
Improper acceptance.
Okay. IV non-compliance of the provision of so and so rules.
Improper acceptance ତାଙ୍କର ଆମେ କହୁଛୁ ସେଟା 4 ଭିତରେ ଆସିବ by any non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act.
either ଯଦି ହଜୁର satisfied ହେବେ IV ଅନୁସାରେ then you may come to I ଆଗ ଦେଖିବେ କି non compliance ଟା ହେଇଛି କି ନାହିଁ ଯଦି there is no non compliance in view of this honorable court then I does not apply.
No, improper acceptance if it has if it is likely to have affected the result of the election that is
so main criteria
right. So whether the question is that whether by deletion of one part
that is
or some line even if it is comes that it should not have been in that form, but whether it can be said that the result of the election has been materially affected because of such non-mentioning or deletion of that part.
That part of evidence or statement is conspicuously absent in their evidence. Your Lordship may note it, I will.
Because every case of improper acceptance would not be a ground to declare the election void. Those improper acceptance which would otherwise would have affected the result of the election, only that will.
Say that again, kindly.
So every improper acceptance of nomination paper cannot be a ground to declare the election to be void. Only such improper acceptance which is likely to have materially affected the result of the election can be a ground to declare the election to be void, right?
Then, my Lord, may kindly come to Handbook of Returning Officer, Exhibit 38. Appropriate form है 5.5.1 clause.
5.5.1. Okay.
Relevant form for filing a nomination of a candidate at an election to the State Legislative Assembly is Form 2B. Then, Your Lordship, then, my Lord, 5.6 number of proposers for nomination.
5.6.
5.6.
Okay. These are referred to that Exhibit 38.
38.
Okay.
One elector of the constituency as a proposer, if the candidate has been set up either by a recognized national party or by a recognized state party in the state or state in which it is recognized as state party. See part 1 of Form 2A and 2B. Then II hela 10 electors of the constituency as proposers.
That is for the other candidate.
Minor. Presentation of nomination, time, place of filing nomination. 5.7 tala presentation of nomination. Then clause 5.9. Who can file nomination? Kindly come to exhibit 38/3.
38/3.
3.
সেটা exhibit 38 ର page 357 ରୁ 362
357 କହୁଛନ୍ତି ହଁ 357 କୁହନ୍ତୁ।
ସେଇଥିରେ ଅଛି all nominations paper are required to be presented in person before the returning officer or specified assistant returning officer either by the candidate or by proposer, and then the handbook for returning officer exhibit 38, that is form 2B, has been marked as exhibit 38/3, available at page 357 to 362.
Right. ଅଛି ମୁଁ ଦେଖି ସାରିଲିଣି।
Part 2 ତଳଟା ସାର୍ ଟିକେ ଦେଖନ୍ତୁ। To be used by candidate not set up by recognized political party.
My lord, ସବୁ ଟିକେ ଯେତିକି nomination paper exhibit ହେଇଛି ଦେଖି E/2, F/2, ସେଇ part 2 ତଳଟା ଖାଲି exhibit E/2, ସେଠି part 2 ତଳେ ଦେଖନ୍ତୁ this line is not
Missing.
missing. Exhibit F/2 ରେ ମଧ୍ୟ missing. Exhibit G/3 ରେ ମଧ୍ୟ missing. Exhibit H/3 ରେ ମଧ୍ୟ missing. These 4 are with respect to election petitioner. Exhibit AN ରେ missing. Exhibit AP ରେ missing.
ମାନେ କୋଉଟା ମିସ୍ କରୁଛି part 2 ଟା?
Part 2 ର ତଳ line ଯୋଉଟା ଲେଖା ହେଇଛି to be used by candidate not set up by recognized political party. ଯୋଉ bracket this line
It's all right. It's it. So
ସେଇ exhibit ଗୁରା ଟିକେ
no, it's all right. ଏଠି I was pointing out to Mr. Mishra that ଏଇ ଯୋଉ line ଟା ଯେମିତି ଅଛି
ଆଜ୍ଞା
part 1 ର just ଉପରେ ଗୋଟେ line ଯୋଉ ଅଛି strike of part 1 or part 2 below whichever is not applicable. Similar option is not there in part 3A, right?
part 3 ରେ ଅଛି ନା
କୋଉଠି part 3?
part 3 ରେ ଦେଖିବେ
ଯୋଉଟା ଆପଣଙ୍କୁ applicable ନୁହଁ delete କରିବା ପାଇଁ କୋଉଠି ଅଛି strike off କରିବା ପାଇଁ?
part 3 ଟା ଦେଖନ୍ତୁ 3 ଟା
3 ନୁହେଁ 3A ଟା we are asking on 3A. That is the yes.
ନାଇଁ ଏଇ ଯେତେ ଗୁଡାକରେ ଏଇ ଯୋଉ ସିଙ୍ଗଲ ଲାଇନ ଟା ମିସିଂ ଅଛି ତାହେଲେ କଣ ଆମେ ଧରିବା ଯେ ଏଇ ଯେତେ ନମିନେସନ ଫାଇଲ ହେଇଛି ସବୁ ଗୁଡାକ not in a prescribed form and liable to be rejected?
No. Their argument is that their case is that you number 3 re let us take one column. Number 3 re lekha ichi whether the candidate has been declared to be insolvent by any court. Hala? So yes or no achi. ଯଦି yes ହେଇଥାନ୍ତା ତାହେଲେ ଆପଣ ଏଇଟା ଲେଖିଥାନ୍ତେ ଅର୍ଥାତ୍ ସେକେଣ୍ଡ ଲାଇନ ର ଆବଶ୍ୟକତା ପୂରଣ କରିବା ପଡିଥାନ୍ତା କିନ୍ତୁ ଆପଣ ତ ନୋ ମାରିଦେଲେ ନୋ ରେ ଠିକ ମାରିଲେ ନା ନୋ ଲେଖିଲେ ଯାହା ବି ହଉ ଆଉ ତେଣୁ ସେକେଣ୍ଡଟାରେ ସେକେଣ୍ଡ ଲାଇନ ରେ ଆଇଦର ଆପଣ ଏନେ ଲେଖିଦେଇ ପାରିଥାନ୍ତେ ନଚେତ୍ କିଛି ନ ଲେଖିଥିଲେ ବି ଚଳିଥାନ୍ତା କିନ୍ତୁ ତାଙ୍କର କେସ୍ ହଉଛି ଆପଣ ଡିଲିଟ କାହିଁ କଲେ ସେଇଆ ତ ତାଙ୍କର କେସ୍
ନାହିଁ ଏଠି ଯାହା ଡକ୍ୟୁମେଣ୍ଟ କହୁଛି ଯେ ପ୍ରିଡିଂ ରେ ତ ନାହିଁ ସେଟା
ଆରେ ଲେଖି don't repeat that I have already noted that pleading re nahi evidence affidavit re nahi that I have already noted. Don't repeat it. Yes.
ଏଇ ଏକ୍ଜିବିଟ୍ ଗୁରା ଯେତେ ହେଇଛି ନମିନେସନ ପେପର
Yes.
ଆମ କହିବା କଥା ଯେ ଏଇ ଯୋଉ ମୁଁ ଏକ୍ଜିବିଟ୍ ଗୁଡାକ ମୁଁ ମାର୍କ କରେଇଲି ଆପଣଙ୍କୁ ସେଗୁଡାକରେ ଏଇ ଲାଇନ ଟା ନାହିଁ ନମିନେସନ ପେପର ଯୋଉଟା ଅଛି କି ଆପଣଙ୍କର 38/3.
These are the nomination papers of the election petitioner.
No, other candidates also.
ମାନେ କୋଉ ଲାଇନ ଟା ନାହିଁ
ସେଇ ଗୋଟାକ ଦେଖଉଛୁ
part 2 ର ତଳଟା ଯୋଉଟା
part 2 ର ତଳ କଣ
part 2 ରେ just ତଳେ ଗୋଟେ bracket ରେ ଅଛି instruction
part 2 ର ଆପଣ ଏଇ ଯୋଉ ଇଏ 352 पेज ତ
357
357 ରହିଯାଅ ଟିକେ ରୁହନ୍ତୁ 357 yes ହଁ part 2 ର part
instruction ଅଛି
bracket ଅଛି to be used by candidate not set up by recognized political party ଏଇଆ ହିଁ ଅଛି
this line
ହଁ
in all the nomination papers exhibited
ହଁ
is missing
ମାନେ just part 2 ଟା କଣ ଟୋଟାଲ ନାହିଁ କାହାର ଇଲେକ୍ସନ ରେ
ଅଲଗା ଅଛି this line particular जो bracket instruction ଟା ରହିଲା that is not there in all the nomination papers ସେଇ exhibit ଗୁରା ମୁଁ ଡାକି ଦଉଛୁ ଟିକେ ଲେଖି ଦିଅନ୍ତୁ ଦେଖିବେ
what you mean to say that not only part 2 ତ ଇଏ delete କରି ଦେଇଛନ୍ତି ଟୋଟାଲ କିନ୍ତୁ ଅନ୍ୟ ଯୋଉ ମାନେ part 2 ଲେଖିଛନ୍ତି ତା ଦେହରେ ସେମାନେ fill up ଯୋଉ ମାନଙ୍କର କରିବା କଥା ତ ସେଟା
ଦରକାର କଥା କାଟିଛନ୍ତି
ହଁ
କିନ୍ତୁ ଏଇ ଯୋଉ ଲାଇନ ଟା ରହିଲା
ସେ ଲାଇନ ଟା particular line okay
so all the nomination paper are not exact verbatim as per exhibit 38/3
contention ଆମର ହଉଛି every departure in the nomination paper is not fatal ଏଇଟା ଟିକେ note କର
okay that means
ଏଇ ଯୋଉ ଲାଇନ exhibit ଗୁଡାକ ମୁଁ ଡାକି ଦଉଛି
ହଁ ହଁ
Hello, all these exhibits, neither is there any pleading nor my lords.
କରିବେ ମିଳନ ଆର୍ଗୁମେଣ୍ଟ ବେଳେ ଆପଣ କରିବେ keep yourself don't disturb
No, I am disturbing because you are going away beyond your pleading.
further ଆପଣ କରିବେ argument
just Mr. what is that line you said every departure from the just
every departure in the nomination paper is not fatal here are the nomination papers exhibit G3
ଲେଖୁଛି ପରା କୁହନ୍ତୁ
E/2 F/2 G/3 H/3
ଏଗୁଡା କାହାର ନୋମିନେସନ
ସମସ୍ତଙ୍କର
last year ମୋଦିଙ୍କ nomination
exhibit AN exhibit ହେଇଛି exhibit AP
ଏଗୁଡା କାହାର ମାନେ ଏଇ ଯୋଉ ଆମର ଏଇ କେସ୍ ର ନୁହେଁ
ଏଇ କେସ୍
yes no it's all right but don't go to that extent
cross examination ରେ ଆମେ pleading କି ଯିବୁ
yes Mr.
exhibit AR by small I bracket ରେ
yes
exhibit AU
yes
no সেটা exhibit AU exhibit DP exhibit DQ by 1 exhibit DR by 1 exhibit DS by 1
all right that's enough just see let us
exhibit DT by 1 sorry gala ଏବେ ଟିକେ ଦେଖନ୍ତୁ ଡାଇରେକ୍ଟଲି ଖୋଲିକିରି exhibit AS by I and AT by Y anyone ଗୋଟେ
କୋଟା
AS by I
just ଗୋଟେ ଦେଖିଲେ
that is also downloaded
just AS
by I
AS kind PH अच्छी यदि मैं देखे एस बाई आई गोटे
AS ଭିତରେ ଅଛି ଆଉ exhibit AS ଭିତରେ ଅଛି exhibit AS ଟା ପାଇଲେ
एस बाई हाँ पाइली हाँ कौन
ता पर पेज टा होची AS by I
हाँ पाइली
सेठी देखंतु दैट इज ए डाउनलोडेड टाइप्ड कॉपी
एटा गोटे कहार इंटरनल
श्रीराम पांडे ए
ओ हमर ए कटक रा
कटक 90 बारबट्टे लडुथिले
हां कोटा नाही कोन कहउचंदी
तार देखंतु फर्स्ट पेज देखंतु सेकंड पे पार्ट 2 देखंतु पार्ट 3 देखंतु
पार्ट 2 कोनटा नाही कोनांदी पार्ट 2 देखंतु
एटा अछि देखंतु तापर
हां
तापर पार्ट 3 ए परे पार्ट 4 5 परे 5 रे accept कले returning officer तापर part 6 पर देखंतु 6 पर से checklist आटी देइकंदी along with the nomination. This is downloaded copy. It is not exact reproduction of the.
All right. Next, Miss. Leave it. Yes.
Yes, bhai.
So these are the sections which are relevant, Mr. Mishra.
Mine.
Okay. Now,
out is 15 chapter अच्छा again. Out 15 chapter
quiz,
15 chapter किसी provision लिखी तो sorry.
कौन?
6 chapter 6 scrutiny. Handbook for returning officer exhibit 30.
Chapter 6.
तार नाटा होची scrutiny. Clause 6.2.1. Then my lord 6.3.1. 6.4.1.
So let us sum up, Mr. Mishra. Amaro, you write down it in the. So let us sum up in this way. So far as the part 2 तांकर केस जो अवरमेंट निया इची
Form 2B is not in prescribed form.
Form 2B is not in prescribed form. ताकु समाने एथी पाई कहउचंती जे part 2
has been deleted.
Number 1. Then part 3A. Part 3A is
clause C II has been deleted.
Part 3 right.
And the part 3 clause E पर जो जाति पे जो paragraph था that has been deleted. Part 3A has not been filled up.
At all.
Column 3 to 9 is not in prescribed form.
Okay. Now there are certain admitted position. Admitted position is, in fact, you have deleted. Part 2.
Part 2 I have deleted.
And you have also deleted in the part 3 era. से जो second line गुड़ा को delete कर जाए, माने 3 to 8 पर्यंत. There is no dispute. जोड़ा undisputed आमे जीवा. एवं आउ
part 3 era.
Part 3 era.
हमें fill up करी ना, आदो fill up करी.
So now
आदो fill up करना होता है, हमें माने dispute कर.
आदो fill up करना टा dispute करचंती, जोड़ा को delete अपन कहउचंती जे ए जो second line delete करचंती.
Whether it constitutes any defect. And if at all it constitutes any defect, whether it is substantial to reject a nomination paper or not.
এবং সেটা ଆପଣ जो पांचटा नंबरिंग करचंती मिस नंबर inaccurate description clerical technical or printing error ଭିତରେ ପଡୁଛି.
That is the evidence of PW3 also, that comes within those 5. Now again I have pointed out that merely because the
said that is not sufficient, court has power to go into.
Whether deletion would come within any of those 5 as enumerated under section 34 na theta
34 provided. 33 provided. And that deletion is not a substantial defect. That is under 36.
Okay. So now
ଆପଣ କହିଥିଲେ କି ପାଞ୍ଚଟା ଜିନିଷରେ satisfy କରୁଛି କି ପଡୁଛି କି ନାହିଁ ଆପଣଙ୍କୁ ଆମେ satisfy କରିବୁ ସେଟାକୁ ନିଶ୍ଚିତ କରିବା.
So that the next you will go to that case numbers, that criminal cases or
no.
Then
are you submissions and citations?
Okay.
ଆପଣ ଯୋଉଟା ଲେଖିଛନ୍ତି ଏ ଉପରେ require citations and ଗୋଟେ ସରିଯିବ ଗୋଟେ part ନହେଲେ ଅଧା ଅଧା ରହିଯିବ.
All right. At the same time on Monday we'll take up this matter.
ନାଇଁ ସେଟାକୁ Tuesday ଟା ଆମର ଗୋଟେ ଅଛି ଜଷ୍ଟିସ ଦାସଙ୍କ ପାଖରେ ଗୋଟେ ଆର୍ବିଟ୍ରେସନ ଅଛି, ସେ 3ଟା 3:30 ବେଳୁ ଆମକୁ ଯିବାକୁ ପଡୁଛି।
I'll take up this matter earlier.
ଏଠୁ ଏଠି ଆସି କରିବୁ, ପୁଣି ସେଠିକି ଯିବୁ, ଯାଇକିରି ପୁଣି ତାଙ୍କୁ ଆଟେଣ୍ଡ କରିବୁ।
ଟିକେ ପ୍ରିପାରେସନ ଲାଗିବ ଆପଣଙ୍କୁ କେସରେ ସବୁ ଦେଲା ବେଳକୁ।
ବୁଧବାରକୁ ରଖନ୍ତୁ,
କଣ୍ଟିନ୍ୟୁଅସଲି କର।
ବୁଧବାର, ଗୁରୁବାର, ଶୁକ୍ରବାର।
ତାପରେ ଉଇଟା ବି କଣ୍ଟିନ୍ୟୁଅସ ସାର୍।
ବୁଧବାର ହେଲେ କୋଉ ତାରିଖ ପଡୁଛି? ଏଟା ମାନେ 13 ତାରିଖ ପଡୁଛି। All right, 13th ରେ ରଖିଦିଅନ୍ତୁ 3ଟା ବେଳେ ହେଲା। ସବୁ ଯିବ ଭାଇ, ଏଗୁରା ସବୁ ଲେଖା ହେଇଛି ନା, ଯିବ ସବୁ। ସବୁ ଯିବ ଆଜିର